from the other side, I beg to mention item number 33. As my senior, Mr. S.K. Mehdi is out of station.
Item number
33.
33. I think you have already circulated an advance adjournment slip.
Yes, sir.
All right.
Yes, sir.
Your name?
K.K. Mehdi.
As prayed for by Mr. K.K. Mehdi, learned counsel, appearing on behalf of the petitioner.
No, respondent.
Respondent with advance adjournment slip, which is not opposed by the other side. Relist after
2 weeks.
2 weeks on a date to be fixed by the registry.
May his lordship, my lord, with the consent of the other side, I beg to mention item number 25, my lord.
What do you want in 25?
I pray for a week time, my lord.
25.
My lord.
You are for?
For the petitioner, my lord.
As prayed for by MS?
Kiwa Pangla.
So and so, learned counsel appearing for the writ petitioner with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
1 week time.
1 week.
At that may be fixed, my lord.
Next.
May I please your lordship? Lordship, with the consent of the other side, I'd like to mention item number 23, lordship.
I think an
Yes.
adjournment slip is given. Counsels for hearing matters, I shall appreciate if an advance adjournment slip is given. It saves our time. Yes.
Sir, can it be on 21 August, lordship? 21/8.
As prayed for by Mr.
W. Rahman on behalf of Mr. A. Sharma.
A. Sharma. Learned
K. Kalita name will be there, lordship.
K. Kalita, learned counsel appearing for the respondent.
Yes.
With by circulating advance adjournment slip with consent from the other side, relist on such and such date. Give that date.
21st.
My lord, item 32.
Yes.
Lokeshwari Bomo. My lord, actually, I am sorry to say that due to shifting of some
When do you want it, Mr. Mahmood?
day after on Monday.
Not,
On Monday.
next week. As prayed for Mr. M.A.U. Mahmood, learned counsel for the writ petitioner, relist after a week on a date to be fixed by the registry. Next.
May I please your lordship? Lordship, with the consent from other side, I beg to mention item number 29, lordship.
29.
Yes, lordship. I am appearing on behalf of Mr. T.P. Bora, standing counsel of Health Department, lordship. In this matter, instruction was called for. Some instruction we are receiving today only, so matter may be possible for.
Who's appearing for the petitioner? You've taken consent.
Yes, lordship.
In item 29, please take down Mr.
U. Ghosh, lordship.
U. Ghosh, learned counsel, appearing on behalf of Mr. D.P. Bora. Bora, learned standing counsel. Health and Family Welfare submits that the instructions, though his office has received the instruction as called for by the last order passed by this court, however, the same is not complete and accordingly seeks a short accommodation. Prayer is not opposed. Relist after
Any date, as per your lordship's convenience.
by when can you have the full instructions?
Next week, lordship.
List after a week on a date to be fixed by the registry.
Obliged, lordship.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 22, lordship.
20.
22. In this matter, I need to get some instructions from my client, lordship.
Lordship, 21 and 22 are tagged together.
21 and 22 are tagged. You are in.
I'm S. Goel on behalf of Mr. P.D. Nair.
So, Mr. Nair is appearing in both the cases?
Yes, Lordship.
Do you have any objection to the adjournment that has
No,
been
Lordship.
sought? But you see, this is a 14 matter.
Lordship.
What instruction do you need?
Lordship, I am appearing for some of the respondents. I need to intimate that.
Intimate them what?
Lordship.
What is the issue? Payment of financial benefit. Right. What instruction you want at the hearing stage of a 2014 matter, Mr. Counsel? Please enlighten the court.
Lordship, I need some time, Lordship. I will get.
What instruction do you need, Mr. Counsel?
Lordship, in this matter, my earlier senior who was leading the case, he has got elevated, Lordship. So whether he is going.
All right. Heard, Mr.
Ardeka, Lordship.
Ardeka, before that you say, don't say heard. As prayed for by Mr. Ardeka, learned counsel appearing for respondent number
8, 9, 17.
8 to 8, 9 and 17.
19 and 23.
8, 9, 17 and
19 and 23.
23. Please give a appearance slip which is not opposed by the other side. Relist on such and such date. The date did after 2 weeks.
Lordship.
Is it sufficient or not?
Sufficient.
2 weeks. In order to enable the learned counsel appearing for the aforesaid respondents to make alternative arrangement for representing the said respondents.
Lordship, my apology. On 27th of August, my senior PD9,
Please tell me a date.
26th of August,
Yes.
Obliged.
highly obliged.
Please call the list. Yes,
My lord,
mention.
no, my lord, item number. My lord, item number one may be closed because, my lord, the petitioner has already died. Her only son is alive, my lord, but he is instructed, my lord, he is not wanted to proceed.
So are you withdrawing?
Withdrawing, my lord, or close?
Close for what? If you are withdrawing, I
Withdrawing, my
should,
lord, withdrawing, my lord.
your name.
T-shake, my lord.
Mr. P. Sheikh, learned counsel appearing for the writ petitioner. Yes, anyone there for the Allahabad Bank? None appears for the respondent on call. Mr. So-and-so, learned counsel for the petitioner, submits that he has received instructions not to press the petition. Accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, writ petition stands dismissed on being withdrawn.
Highly obliged, my lord.
Up to
Yes, are you agreeable for sending it to the mediation?
My lord.
What about your counterpart? Who's there for the respondent?
What are the department?
Respondent? Please get hold of someone from the water resources. Then if both parties are agreeable, I shall refer it.
item 3.
My lord,
Agreeable, not agreeable, or instructions?
not required, my lord.
Possibly, my lord,
Is
there may-
Agreeable?
No, mediation may not be required.
May not be required.
Yes, only admitted position, my lord. Kindly see the
mistake in the
page 52.
calculation.
Huh?
Mistake in the calculation.
Mistake in the calculation.
So I think Lordship gives me 2 weeks time, possibly we can sort it out.
Okay. You're right. Heard, Mr.
Okay, Ghosh.
S.K. Ghosh, learned counsel appearing for the writ petitioner. Also heard Mr. S. Datta, learned senior counsel, assisted by M.S.K. Bora, learned counsel for the respondents. It is submitted at the bar that the issue involved in the aforesaid writ petition is about as regards mistake of
Calculation.
calculation. As regards what?
Mistake
As regards the pension due to the petitioner. Mr. Datta so-and-so submits that seeks for a short accommodation in order to sort out the sort out the mistake, rectify the mistake. Stop. Prayer is allowed, relist after such and such date.
My lord, a date maybe because.
Give a date. Yes.
20 August. Monthly.
Obliged.
Item number 4.
May I please your lordship? Lordship, basically the petitioner hearing is praying for the benefit of an OM.
Agreeable, not agreeable, instructions. You have 3 options. Which one?
Whatever you may suggest. Your
No, I am not going to suggest. If parties are agreeable, we'll refer it to mediation. If parties are not agreeable, we'll have it relisted. And if you want instructions from clients, we will pass appropriate orders. So that's why I'm saying let's not further waste judicial time.
But we are not
Choose.
agreeable.
Not agreeable.
Not agreeable because legal issues are involved.
All right, not agreeable. There is a draft order for that.
My- So, like,
Yes.
5.
Deep to like.
Agreeable, not agreeable, instructions. No parties.
and for accounting general.
No, it will acquire mati dibo. All right, after some time.
6. Not agreeable.
Not agreeable.
1 year.
All right, item 6, not agreeable, but councils, please put your representations. Just give your appearance slip,
Yes.
huh? Yeah, go to Lulu Bhutan. Not agreeable 6.
Law point is there.
Okay. We did not specify that. Yes.
Item 7.
My pleasure, Lordship, my item was 5.
Yes. Wait for your turn. You cannot just budge in. Huh? Are you appearing in item number 7? Are you appearing in item number 7?
No.
Then why are you interfering with the judicial proceeding? Is this the manner you come and appear. Wait for your turn. Inform the court master. Yes. Agreeable, not agreeable. Very good. Mr. Chutia, agreeable? This is a mediation you try. Please give your appearance slips. Huh? This is agreeable. And a copy of the order will be given to all the council. So you will know when to go.
Item 8 and 9.
7 is agreeable. Huh? So this is 8 and 9. Yes, agreeable. Agreeable? Very good. Item 8 also agreeable. 8 and 9 both.
8 and 9 both.
Agreeable. But kindly give your appearance slips, otherwise, because I want that all the orders be furnished to the learned counsel so that you can, give it to your respective clients. So please give your names, huh? 8 and 9 agreeable. Yes, 10. Family instruction, pension. Agreeable, Mr. Kalita, na? Where is your counterpart? PNRD, Finance, Government of Assam. Get hold of someone, Mr. Kalita. I'll pass necessary orders.
Item number 11.
Yes, 11.
Yes, Madam.
Huh?
Agreeable, Madam.
Agreeable, Mr. Deka. Very good. Agreeable, huh? Please give your appearance slips. Yes.
On education.
Before we go to the admission, any counsels present from those time being of the referral matters? Both sides. Asisji mati dio, eto khatam kori dio.
Has been item 2, 5, 10.
You are there? In item 5? 5 to dio. Yes, 5. Are you agreeable? Not agreeable or instructions?
The instruction is not received.
Not received.
Not
So you want to get your instructions? Who is appearing in the other side? Government of Assam, AG, PHE? Yes, government, PHE. Ms. Barwa, can you just put their names? Can you just inform the names? We will give them the order. This is for instructions. Get your instructions.
On admission. Item number 12.
12, my lord, I request some time, my lord, for filing the.
In 12, you want some time? As prayed for by Mr.
I second.
So and so, learned counsel appearing for the writ petitioner, to enable, you want to file a rejoinder?
Right.
To enable the petitioner file rejoinder against the affidavit in opposition filed by the state government, 3 weeks. List after 3 weeks and a date to be fixed by the registrar.
Madam, here, Madam, I am seeking some time also, Madam, to file an affidavit on behalf of.
In the meantime, finance department, if so advised, may also put their return.
I'm so obliged. Item 13.
Councils, in any matters, you want your names to be recorded, give the appearance slip. Wherever we receive the appearance slip, we will record it. Otherwise, it takes a lot of time in recording everybody's name. All right? Yes.
Item 13.
Judge, by appearance slip.
The record was called for one of the service.
Yes, records
Record yet to come, Lord.
yet to come.
For the 2 weeks order time, Lord.
Records were called in June. All right.
Date may be fixed. Lord.
Heard Mr. A. Ganguly, learned counsel appearing for the writ petitioner. Also heard Mr. A. Chakrabarti, learned government advocate, State of Assam. Stop. Who's appearing for 5? None appears for the respondent number 5 on call. Mr. Chakrabarti so-and-so submits that the records as called for earlier by this court is yet to be received and accordingly seeks a short accommodation. Prayer is allowed. Relist when?
After 2 weeks. Lord.
After 2 weeks on a date to be fixed by the registry. Mr. Ganguly.
I have given an.
All right. Give a date after 2 weeks.
21st.
After 2 weeks, a date.
22.
All right, councils, you sort it out.
22,
Yes, next matter.
22nd.
Obliged. Item number 14.
Yes.
here in this case, Lordship, the record is sought for Lordship, not received, Lordship. Kindly fix the matter in the next week.
Mr. J.K. Goswami, learned government additional
Senior government.
senior government advocate, submits that the records as called for earlier by this court is yet to be received and accordingly seeks a short accommodation. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. Interim.
Date may take on 19, my lord.
It will come, Miss Counsel. Registry will, if you have any difficulty in getting your matters listed, please feel free to approach the bench. Yes.
Item 15.
Yes, affidavits appears to have been filed.
Affidavit has been filed. Also, may kindly fix the matter on a hearing date, my lord, so that.
Why? What is the issue? Payment of
BCA, Bhutan compensatory allowance, my lord.
what compensation?
Bhutan compensatory
Bhutan.
allowance. my lord.
What is that?
My lord, the petitioner was working, my lord, in Bhutan. For working in Bhutan, my lord, special compensatory allowance is paid to the.
That was denied.
That was not.
Why? What is the stand?
The stand is that, but I was posted in India, but my duty was in Bhutan. As I was posted in India, they did not pay me the compensatory allowance.
Is there any guidelines, any
Yes,
rules?
yes.
So as per the rules, is the petitioner entitled?
No, he's not
Then
entitled.
where is the question
No,
of
he
your
has come within
entitlement?
the
Mr.
zone of
Saikia?
consideration.
The Honorable Apex Court in number of cases, well, decided this issue. In
Where is those decisions?
Well, that is there.
That is there where? Give. Let us have a look. Matter is fixed for
Yes,
admission.
my lord, our cases, my lord, he doesn't come within the zone of consideration first. Secondly, my lord,
Which
his-
paragraph of your
my
affidavit?
lord, 5, 8 and 12 kindly. Your Worship.
Paragraph?
Paragraph number 5, 8 and 12.
Page.
This is my lord, page, my lord, page 49 it starts, my lord.
Yes, page 49.
Yes.
Yes.
With regard to the statements made in para 2 of the writ petition, the answering department involved personally agreeing to the same makes the statement. Based on available records, the petitioner was appointed as DBRMT, that is driver, not a mechanical truck. By Grave Center and Records, DG came Pune on so and so, and further posted in so and so. The petitioner reported to unit on 25th March 1999. The petitioner was awarded 14 days pay fine by then OC for 91 RCC for an offence under Army Act Section 48 and Army Act Section 63. By 91 RCC Part 2 Order number so and so.
Slow. You have a flight to catch.
My lord, sorry, my lord.
Why are you going so fast?
Sorry, my lord.
Yes, Mr. Shizia?
Yes.
Correct. I don't know, maybe I'm sending a wrong message
No.
that I go
I'm sorry,
fast. I
I'm
go
sorry.
fast when it is needed. Now I'm hearing, go slow.
Yes, sorry, my lord.
Yes.
Now, Lord, so the petitioner reported to unit on 25th March 1999. The petitioner was awarded 14 days pay fine by then OC 91 RCC for an offence under, this is Army Act, Section 48 and Section 63.
Section 63 and 40?
48.
48.
By 91 RCC Part 2 Order number so and so dated 26th June 2001. The petitioner was again awarded 14 days pay fine by then OC 91 RCC
For an offence.
So, my lord, as per existing policy, that is important. Posting order to Bhutan is applicable only to those employees who have never been awarded
Major punishment.
Major punishment.
So here you are saying that this petitioner has been already awarded major punishment.
No, minor punishment.
Minor
Yes.
punishment.
Awarded major punishment during the entire service and minor punishment during the last 10 years of service.
So here he has got minor.
Yes. Both the offences come under minor offense.
And this was within 10 years.
Yes, because he was appointed on 20.
So therefore he is not qualified
minor.
to receive that.
Yes.
He was not posted.
Yes.
Huh?
For that reason, he could not be posted in Bhutan. That is the stand.
No, it says as per existing policy,
Yes.
posting order to Bhutan is applicable
Yes.
only to those employees who have never been awarded so and so and minor punishment
Yes.
during the last 10 years of service, which
Yes.
clearly disqualified the
Yes.
petitioner from being posted
Yes.
to Bhutan to
Yes.
avail the Bhutan compensatory area.
Yes.
So you see, I understand, Mr. Soikia, what you're trying to say, correct me if I'm wrong. What you're trying to say is that they are saying posting is not possible, but in your case, they have already given you posting.
No.
No, madam.
No.
In my case, I was posted in the border in Doranga. I was posted in Doranga, my lord. And my lord, I was to carry the my vehicle to Bhutan on
So
regular
for,
basis.
why, how you are allowed
My
to
duty
get
was-
the Bhutan compensatory?
My duty was within the Bhutan area, my lord.
But there is no guidelines, no rules which says that you are entitled to avail the Bhutan compensatory area because you are not, firstly, you are not even posted. Secondly, assuming you are posted, that would have been also illegal because you can't be posted because you have admittedly 2 minor punishments have been already awarded to you during 10 years. Correct?
My lord.
So then where do you have a case?
I am not
Lord,
claiming
kindly
for
come to
posting.
para 8
My
now,
case
madam.
is that
Para
All
8
right,
is-
I'll come to you, Mr. Saikya.
Para 8 is also very important. Madam, page 52. Para 8 is also very important. Para 8, next para 12. Para 8, page 52.
Yes.
That while denying the correctness of the statements made in para 5 to 8 of the writ petition, the answering deponent begs to state that the petitioner was in posted strength of, this is important, ma'am.
Yes,
5
yes.
to 9 SS and TC, this is one of store supply and transport company, Gref, from 5th December 2005 to 5th January 2009. He was temporarily deployed, he was not posted there in Doranga. He was temporarily deployed from 5 to 9 SS and TC Gref to 63 RCC Gref Doranga in India with effect from 24th June 2007 to 23rd December 2008 for his trade work, and as such the petitioner is not entitled to Bhutan compensatory allowance. As per existing posting policy, Gref personnel permanently posted to headquarters, chief engineer, project Dunter, and units under command located in Bhutan.
This is clear.
Yes. And next, my lordship, kindly come to para 12. Para 12, lordship will find it page 53, next page, my lord.
Yes.
It doesn't come in the zone also, my lord. That while denying the correctness of the statements made in para 12 of the writ petition, the answering deponent begs to state that, as per the existing posting policy, Gref personnel fulfilling all eligibility criteria and on merit basis are being posted by Gref records to able foreign posting.
Wait,
That-
slow. You are again
Yeah, I'm
going
sorry, I'm
fast.
sorry.
As per the existing posting policy, GREF personnel, read,
Fulfilling
fulfilling.
all eligibility criteria and on merit basis are being posted by Gref records to avail
Mail foreign
posting.
posting.
Yes.
So
that is-
here to first of all, he didn't have a foreign posting.
No.
He was only going there for
Yes.
trade work.
Yes, my lord.
Yes.
That is his related trade work. And my lord, he has to come back on the same day after dropping the materials, my lord. Bhutan compulsory allowance posting.
And this allowance that he's seeking is the Bhutan compensatory allowance BCA posting.
Yes,
Correct?
Yes, for a prescribed period, my lord. In compliance. with
One
the-
sec. Looks like you have a lot of cases today. Then why are you so fast today?
Reading fast, my lord. So, I'm very sorry.
No, don't be sorry.
The next line, may I read?
One sec. Yes, now read.
In compliance with the above policy, Gref personnel of trade of MT, this is also very important. Trade of MT, that is a mechanical driver, to which the petitioner also belongs, who were appointed on or before May 1st May 1995, have come up in the panel for consideration in the quarter ending June 2023, based on their merits and fulfilling all eligibility criteria. Accordingly, eligible persons in the above panel have been posted to BCA, whereas the petitioner, Mahendra Singh, was appointed on 21st June 1999. So he didn't come within the zone.
Why this I didn't understood. Why you said he is not
Because
coming within the zone?
Cutoff was fixed. So persons, since the vacancies are very restricted, so this policy was adopted. So can see, who were appointed on or before 1st of May.
And he was appointed when?
21st of May, January 1999.
So
For later.
on or before?
Yes.
So he was after.
After.
So this is according to you, this is applicable to only on
Or before.
1st
of May 1995.
1st
For posting.
1995.
Yes.
And the petitioner is appointed on
21st of January 1999.
93. Okay. 1999. Yes, Mr. Saikia.
This is for the purpose of Bhutan posting, my lord.
Because you are also seeking that compensation.
My lord.
The compensation that you are seeking is the Bhutan compensation
Compensatory.
posting, correct?
My case is that, my lord, though I was posted in India.
But
in
you
the
had
field of-
gone there to carry out your work.
My work was, my job was assigned in Bhutan.
Now, which
had-
part of the notification says that even if you are not posted and you have to travel to Bhutan on a daily basis in connection with your work, you are liable, you are entitled to get the Bhutan compensatory. Please show me that.
Kindly fix the matter
No,
on Tuesday.
no, no.
On Tuesday.
Mr. Saikia, I am not adjourning this matter.
Of the day after tomorrow.
There is nothing you can do.
Do after-
Show me.
I will make the submission, my lord, on the basis of the decisions of the apex court, my lord.
Apex court
That-
decisions are contextual.
My lord. Same issue.
Please,
my lord,
please,
Same issue.
please say.
So, my lord, Losime,
Well,
please,
of course, in that case, there must be a posting. I am asking you a very direct question, Mr.
I am not
Saikia.
posted. I am not posted. at-
Correct, you're not
I'm posted
posted.
at Bhutan.
So if you're not posted, you have no case. That is it.
My lord.
Until and unless right now you show me that this rules also apply on a daily visit.
Losime, kindly take up the matter tomorrow.
Sorry.
Yes, taking up as part
Yes.
of matter, my
They
lord.
have filed the
As
rejoinder.
part of matter, Losime, take up the.
Where is the rejoinder?
Yes, no, they have filed. the rejoinder.
Where is the rejoinder? Paragraph, please point out the paragraph.
Yes, Lordship may kindly come to para 8. He says, well, he was not posted to Bhutan. But
I
my
am
lord, he
admitting that.
executed
I'm not
certain
denying.
works.
I am not denying that I have.
Paragraph 8.
Yes,
Yes,
just claiming benefits, my lord.
very well.
And my lord, the statements which were made in para 5, 8, and 12, my lord, they have
Mhm.
denied it. Just now I read it, my lord. Reply to para.
Very well.
of our
Yes,
affidavit.
please take
My
down.
lord, Losime, kindly take.
Mr.
take
Saikia,
tomorrow, my lord.
take
For
your
one day,
seat.
my lord, for one day, my lord,
Sorry.
kindly adjourn the matter, my lord.
No, 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 unnecessarily.
That
You see, this court cannot go on adjourning matters unnecessarily. The matter is posted today for admission. You should have prepared and come. Yes, please sit down. I'll take care of the judgment. You sit down. Heard Mr. I.H. Saikia, learned counsel appearing for the writ petitioner. Stop. Also heard Mr.
MR Adhikari.
MR, na?
Yes.
MR Adhikari, learned
CGC, my lord.
CGC.
For all the respondents.
By way of this petition, under Article 226 of the Constitution of India, the petitioner is claiming benefit under the Bhutan compensatory allowance within bracket BCA rules within bracket while working in Bhutan against the work performed by the petitioner as driver in Bhutan for the year 2006 to 2009 within bracket 26 months. Full stop. The brief facts of the case is that the petitioner was initially appointed as driver in GREF Center and Records, Dighi Camp, Pune on 21/1/1999, and thereafter the petitioner was posted, and later on, not thereafter, and later on the petitioner was posted as driver at GREF under the control of Chief Engineer Project Vartak Tejpur, wherein he is presently working. Correct? You're presently working there, na? It is the specific case of the writ petitioner that during the course of service, he was transferred from GREF Center and Records, Dighi Camp, Pune, to the office of Officer Commanding 529 capital SS and TC within bracket GREF, Guwahati. And while he was working as driver in the office of the officer commanding 529 SS and TC within bracket GREF, Guwahati, he was ordered to work as driver in Bhutan by the direction and policy issued by the Ministry of Defense, Government of India in the year 2006, and was detailed from the office of Officer Commanding 529 Stores Supply and Transport Company within bracket GREF, Guwahati within bracket State of Assam, India, to the office of Officer Commanding within Officer Commanding 63 RCC within bracket GREF, Dantak, Bhutan in the year 2006, and the petitioner assumed his duty as driver in Project Dantak within bracket Bhutan in the year 2006. It is the further case of the writ petitioner that after the petitioner joined the aforesaid office in Bhutan, he discharged his duties as driver of vehicle, namely Tata TPR within bracket vehicle number 98 capital E-66288X bracket close, and Tata Load Carrier within bracket TRALLA vehicle number 04E-60117X for the supply of construction materials from India to Bhutan and within the territory of Bhutan during the year 2006-2009 within bracket around 26 months. You will get these in para 4, the details. Just cross-check. It is the further case of the writ petitioner that since he was discharging his duties as driver for supplying the material to Bhutan, he is entitled to be paid the payment as per Bhutan compensatory allowance within bracket BCA rate, i.e. the payment which should be given to any employee who had discharged his duties outside India, i.e. in Bhutan. Stop. However, since the petitioner was given the salary as per the normal rate to the driver in India, you filed a representation. He filed an application on 22/8/2023 before the respondent authorities to provide the areas of payment to the petitioner for performing his duties as driver in the foreign country for the year 2006-9 within bracket 26 months approximately as per Bhutan compensatory allowance within bracket BCA rate. However, since the aforesaid application did not bore any fruits, the present writ petition has been filed. Stop. Mr. I.S. Saikya, learned counsel for the writ petitioner, submits that since the petitioner has been discharging work at Bhutan by driving the official vehicle as per the office order, whereby he had carried construction materials from India to Bhutan, he is entitled for the compensatory allowance as claimed. In support of the claim, he relies upon the following decisions. number 1. Union of India versus Amarnath Prasad. Dated where is the order? This is the SLP is dismissed. Mr. Saikia, this SLP is dismissed. You mean to say by confirming this?
Yes, ma'am.
The Amarnath case. Huh? Is that your submission?
Yes, ma'am.
That is why you give that SLP. Then you say it like this. He relies upon the decision of the division bench of the Delhi High Court in Amarnath Prasad versus Union of India in CM number 3954 of 2007 and LPA number 618/2002. Paragraph, Mr. Saikia, wherein the Honorable Delhi High Court.
That I missed. Well, I'm
Huh?
sorry.
What kind of a preparation do you do, Mr. Saikia? This is not expected from a counsel like you with so much experience.
I'm sorry, madam.
You must not take up these admission matters so casually.
I sought for time.
Matters are posted before the Constitutional Court. This is not how you prepare. This is absolutely not correct, Mr. Saikia. Please don't take the courts for granted. I am warning the bar. Please don't do it.
That is why I was
This is not right. Either you take time at the mentioning and otherwise you be prepared, because you cannot come with the guarantee that you will seek for posting the matter for hearing and the matter will be on its own course be posted for hearing. Matters are listed for admission for a purpose. Just because the counsel says this matter can be listed for hearing doesn't mean it will get listed automatically for hearing. You have to also make out a case for admission before the court decides to admit and put it for hearing.
That is why I was seeking for.
Then you have to seek it at the first instance, at the mentioning stage. Your submission before this court was that this matter can be taken up for final hearing.
My friend was making the submissions, madam.
Anyway, please sit down now. Wherein the Delhi High Court granted the Bhutan compensatory allowance as paid to similarly placed employees. Though the aforesaid order was challenged by the Union of India before the Apex Court, however, the same was dismissed. He further places a notification dated 21/11/2001. Please find out where you have pleaded this in your affidavit. When you find the paragraph, please let me know from the writ petition. Mr. Counsel, you can also assist wherever this notification has been pleaded and your response. To show that in case of long tour temporary duties within Bhutan, full admissible daily allowance shall be applicable up to 7 days. comma, 75% of full admissible DA for the next 7 days and 50% of full admissible DA thereafter. Stop. Per contra, Mr. So-and-so, learned counsel for the respondent, submits that the claim of the petitioner for Bhutan compensatory allowance is absolutely frivolous and baseless, inasmuch as the petitioner at no relevant time was posted at Bhutan. He further submits that the applicable rules clearly indicates that it is only on posting in a foreign country, i.e. Bhutan, the Bhutan compensatory allowance within bracket BCA posting is applicable to such employee. Stop.
Permanently posted.
Permanently posted. Huh? Use the word permanently. Stop. Have you found that?
I didn't find
It's not there.
No.
He further submits that the submission of the learned counsel appearing for the petitioner as regards the claim for daily allowance as per the notification dated 21/11/2001 has neither been pleaded nor claimed in the instant writ petition. Stop. I have given my due consideration to the arguments advanced by the learned counsels appearing for the petitioner as well as the respondent. I have perused the materials available on record, and I have also considered the citations, the case law cited at the bar. Stop. Yes?
There are two other grounds, my lord, because my lord, he having my lord, got that minor punishment.
Correct,
he was
correct.
not eligible.
He further, just help me to frame it.
Yes, yes.
He further submits, you put this in the respondent submission. Huh? I'm sorry, I forgot that.
Yes.
He further submits that in view of the fact that the petitioner has been awarded 2 minor punishments within 10 years of his last posting,
Yes.
he is not entitled for the compensation claimed in the writ petition in terms of Rule 42.
No, that is even not
In terms of?
the policy.
In terms of?
The policy of posting.
In terms of the posting policy.
Mine.
Stop. He further submits that assuming, he further submits that in any ways, the petitioner having been appointed on
21st January 1999.
on 21/1/1999 is also not covered under the posting policy, which is only applicable to appointees who have been appointed on or before 1st May 1995. Hence, he submits that the petitioner does not even come within the zone of consideration of the aforesaid policy. Stop. Then that third paragraph. The short issue that falls for consideration in the instant writ proceeding is whether the petitioner is entitled to receive the benefit under the Bhutan compensatory allowance within bracket BCA posting. Stop. It is an admitted position that the petitioner was at no relevant point permanently posted at Bhutan. However, while the petitioner was posted at, which is that place he was posted?
529 SSNTC.
Where do I get the reference?
Para 8 number,
Para
page
8.
52.
However, while he was posted in 529 SS and TC within bracket GREF during 5/12/2025 to 5/1/2009, he was temporarily deployed from 529 SS and TC within bracket GREF to 63 RCC within bracket GREF stroke Daranga in India with effect from 24/6/2007 to 23/12/2008 for his trade work. Stop. It appears that during the aforesaid temporary deployment of the petitioner at Daranga, he was required, he had gone to Bhutan to deliver trade goods. Stop. Relevant paragraph of the before that, where do I find that Bhutan, that compensatory, those rules and all? Is it there somewhere?
Nigeria is here.
Where?
Page 59. Rashmi, kindly see serial number F, page 59.
This is what is this document?
That is a criteria for posting to BCA and MC areas.
In order to determine the issue in hand, apt to refer to the criteria for posting to BCA/MCA areas, which is extracted hereunder for ready reference, quote unquote, page 59, A to A. I think only 59,
Yes,
the entire part.
Yes, that is the extra.
Reading of the aforesaid instruction, Mr. Saikya, this is what it is, a posting policy.
Yes.
Policy. Reading of the aforesaid posting policy for Bhutan compensatory area within bracket BCA stroke Myanmar compensatory area within bracket MCA, comma. It is condition precedent that an employee claiming the aforesaid compensation is posted therein. And it further appears that in order to this viable tenure, should have completed a minimum service of 10 years and then the posting comes, right? And in order, I think this viable tenure should have completed a minimum viable tenure of 2 years in the present unit to qualify for consideration.
Yes.
This is only for the purpose of posting.
That is for the purpose of posting.
Not for the purpose of.
Okay. It further appears that in the event any major punishment is awarded during the entire service of the concerned officer, he or she shall be disentitled for the compensation under the aforesaid posting policy. It further appears that in the event any minor punishment is awarded during the last 10 years of the concerned officer's service, he or she shall also be disentitled for the compensation under the aforesaid policy. Stop. Apt at this juncture to refer to the relevant paragraphs of the affidavit in opposition filed before this court on behalf of the respondent numbers 1 to 4 on 21/2/2025. Paragraph 5, 6, 7, 8, 9, 10, 12. Okay. Reading of the aforesaid paragraphs, it is apparent that firstly, the petitioner was never posted in Bhutan. However, the petitioner has been
Except 2, my lord, of the writ petition. And except 2 of the writ petition.
Annexure 2 of the writ petition. Page.
Page 15, my lord. Is the duty slip of the petition.
Okay, I'll come to that 1 second. You just remind me that, huh? However, the petitioner was, while the petitioner was temporarily deployed at Daranga in India with effect from 24/6/2007 to 23 December 2008, he used to travel to Bhutan in connection with his trade work. In connection with the trade work assigned to him by the office. Right? Stop. It is further apparent that the petitioner, while during his last 10 years of service, was awarded 2 minor punishment, once by the then OC 91 RCC for an offense under AA section 48 and AA section 63, Vide 91 RCC part 2 order number 0/032/0014/2001 dated 26 June 2001, and again by then OC 91 RCC for an offense under A section 63, Vide 91 RCC part 2 order number 0/064/0001/2001 dated 19 December 2001. Stop. It further appears that as per the existing posting policy, in order for a GREF personnel to be eligible to be entitled for compensation under the BCA posting, firstly, he should be eligible, and secondly, it is only on merit basis. It further appears that that the aforesaid posting policy is further applicable only to the officers who were appointed on or before 1/5/1995. Hence, it appears that the petitioner being appointed on 21/9/1999 does not come within the zone of consideration. Stop. Pertinent that the petitioner filed its rejoinder against the aforesaid affidavit in opposition filed by the respondent on 13/5/2025, relevant paragraphs of the same are extracted hereunder for ready reference. Quote unquote. Five, 8, 11, 10. Reading of the aforesaid paragraphs, it is apparent that the writ petitioner admits that he was not posted in Bhutan, but as the work meant for Bhutan posting was executed through him, for which he is claiming the financial benefits. Stop. Page of the writ petition, your duty.
Page 15.
Page
Page 15.
15.
Yes. Is the duty slip?
Apt in this regard to refer to the duty slip, which reads as under. So this page 15 has to be quoted from which part? This is a quite long one.
Long one, my lord. This is this duty slip. My lord, by this annexure 2, the petitioner has established that he performed his duties in Bhutan.
Okay.
That has not been denied by the authority.
So if for quoting, I just wanted to extract it. I think the only page 15 is sufficient.
Sufficient.
Correct?
Sufficient.
I didn't say relevant, relevant portion of the duty slip as enclosed as annexure 2 to the writ petition is
Lordship mentioned as abstract, my lord.
abstract.
Because abstract
Okay.
of the duty slip.
Abstract of the duty slip is extracted here under for ready reference. Quote unquote, page 15. Okay. It appears that the petitioner, in order to buttress the point that while the petitioner was posted at Daranga, he was required to go to Bhutan to supply items as per the direction of the respondents. Stop. A careful reading of the aforesaid what crystallizes from a careful perusal of the aforesaid is that the petitioner at no relevant point of time was posted at Bhutan. However, the petitioner was only going to Bhutan in terms of the direction of the respondent authorities to deliver items as and when he is required to.
On regular basis.
On a regular basis, on a regular basis, during the period in question. In order for the writ petitioner to be qualified, to be entitled to receive compensation as per the aforesaid posting policy, it is condition precedent for the writ petitioner to be posted at Bhutan. However, since the petitioner was never posted and was only going to Bhutan on a daily basis as per the orders of the respondent authority, the writ petitioner cannot claim any benefit under the Bhutan compensatory allowance posting policy. That apart, assuming but not admitting that the petitioner was posted at Bhutan, even then, in view of the fact that 2 minor punishments were awarded, the petitioner is not qualified and entitled to receive the compensation as claimed. Thereapart, the petitioner having been appointed on such and such date is also not covered by the aforesaid policy. It does not come within the zone of consideration. As regards the decision of the Honorable Delhi High Court, the decision of the Division Bench of Honorable Delhi High Court, wherein the Honorable Delhi High Court granted compensation as per the Bhutan compensatory allowance by taking note of similarly, sorry, just say allowance, comma, it appears that in the context of, in the facts of that case, the appellant was posted as per the documents on 22nd 6 1998 at Bhutan. It further appears that the aforesaid posting of the petitioner at appellant at Bhutan was also not disputed by the respondents. In any view of the, be that as it may, the decisions of the division bench of another high court is only persuasive and is not binding before this court. Be that as it may, decisions are only contextual. As regards the submission of the learned so-and-so, as regards the daily allowance, in terms of the notification dated 21/11/2001, the same being not pleaded or claimed before in the writ proceedings in hand, this court is not going into the same. In view of the above, this court finds no merit whatsoever in the writ petition. Accordingly, the writ petition stands dismissed. Sorry, Mr. Saikia.
Number 16 to 19.
You brought your counterpart?
Yes.
Yes, come. It is in 15. Item 10, so agreeable? Okay. I give item 10 to Mafu and agreeable. Please give, Mr. Kalita, just give your appearance slip, huh?
Yes.
To Didi Mama. Agreeable.
Lordship, here in this matter, Lordship, I have received my instructions. Lordship, I need some time to file my affidavit.
Which one? 16 to 19?
Lordship, in item 16 and 19. Lordship.
My lord, here, my lord, item number 16 and 19, my lord. So for 16 and 19 are concerned, we have challenged the termination order. So for 17 and 18 are concerned, my lord, there we have prayed for the, my lord, salary for the period I work. They stopped the salary, my lord, without completing the, my lord, inquiry. With effect from 1/10/2023 till the date of termination on 26/2025.
But I think they are all connected. So let him file it, Mr. Das.
Or my lord, it is up to your lordship, my lord. However, my lord,
They are already by judicial order, they're all tagged.
Please
all right.
the date, my lord.
Yes, that you will get, Mr. Das.
Yes.
Heard Mr. B.K. Das, learned counsel appearing for the petitioner. Also heard Mr. D. Upamanyu.
Yes.
Learned standing counsel, health and health department. Stop. Mr. Upamanyu submits that you have received instructions.
Yes, Lord.
He has received instructions in WPC 3630 of 2025 and WPC 3772 of 2025 and accordingly seeks a short accommodation to file return in the aforesaid two writ petitions. Prayer is allowed. Relist on such and such date. Yes, give a date after 2 weeks.
Declare. 20.
This is in all the 4 matters, huh? Yes, the parties are there.
Item number 2.
In item 2, you say none appears. Relist again next week on a date to be fixed by the registry.
For hearing item number 20.
Here, can this matter be taken up after a week, Lordship? I have taken the consent of the petitioner, Lordship.
Yes. OP, that mediation one, you tell me, I will do a little bit of edit. That order which. Ematra mediation, I took one number, 2. Huh? Yes, Mr. Upamanyu, you want time
Yes,
for
Lordship.
filing affidavit?
No, Lordship, this matter has been fixed for hearing, Lordship. So, Lordship, after a week, Lordship, the petitioner.
Yes, Mr. Sharma.
Yes, my lord. After
That's a 14 matter, Mr. Upamanyu.
Yes, this matter got dismissed for default, Lordship, then it was restored only in the year 2025.
That's all right.
Yes, Lordship.
It has been restored.
Yes, Lordship.
You mean to say now the petitioner is not entitled for a hearing because it got dismissed for default and restored?
No, Lordship.
Then what is the purpose of restoring the matter on in the record of this court, Mr. Upamanyu?
Yes, Lord.
Yes.
My lord, the issue here is the pay disparity.
You have some difficulty today.
Yes, Lord.
When do you want it?
Lordship, next Tuesday, Lordship.
All right. Mr. Sharma, next Tuesday.
Yes, my lord.
Heard Mr. I always get confused with your
M. Sharma.
Mr. M. Sharma, learned counsel appearing for the writ petitioner. Stop. Also heard Mr. D. Upamanyu, learned standing counsel held.
Yes, Lord.
Health and so and so. Mr. Upamanyu, with profuse apologies, seeks a short accommodation in the matter, which is not opposed by the learned counsel appearing for the writ petitioner. Released on such and Tuesday on such and such date. It is needless to be clarified that since the matter pertains to the year 2014, no further adjournment shall be granted in the matter.
Thank you.
Item 24.
Yes, Mr. Pathak. Dismissal from service.
My lord, dismissal, however, it was subsequently converted to compulsory.
Okay.
My lord, our challenge was basically.
There is a counterpart.
But what I find from the affidavit, my lord.
The problem, Mr. Pathak, is the moment I start investing time, then suddenly someone will come and seek for a time.
My lord.
But who's there? Who's there for the other side? B. Sharma, MS B. Sharma, she is generally there.
My lord.
I just appoint.
All right, after some time, you get hold of her, Ms. Barwa.
My lord.
You wait, Mr. Pathak.
My lord. Item 26. 26, my lord, pertains to promotion.
You are only appearing.
My lord.
Here I think Ms. Barwa, she must have gone out to call. All right, we'll take first B. Sharma and then Ms. Barwa, yours.
But as far as 24 is concerned.
Look, 24. 24, Mr. Pathak.
My lord. 24, my lord, we have alleged some procedural irregularities.
What are the procedural?
My lord, however, my lord, to be fair, my lord, however, after filing of the affidavit, when the entire records have come forth.
There are no violation of natural justice.
No, my lord.
So then,
And
proportionate.
No,
Now,
seems, compulsory retirement seems proportional.
So therefore, there is no merit.
No, my lord.
You want me to
Earlier it was
dismiss?
discharged.
You want me to dismiss, or you want me to, or you want to withdraw?
My lord would observe that there is no merit and may be closed.
If we are fortunate that we have such officers also, isn't it? Heard Mr. B. Pathak, learned counsel for the petitioner, also heard MS B. Sharma, learned CGC for the respondent. Stop. By way of this petition under Article 226 of the Constitution of India, comma, Mr. Pathak, you may have to help me with the pages, huh? You take your seat, you can help me from there. Sit down, sit down. Is assailing the impugned discharge order dated 25/3/2020 passed by the respondent number 4, whereby discharge order will requires it to stop. The brief facts of the case, this compulsory punishment happened later on.
Hello.
So that, where do I get that? You just keep that page ready.
My lord, in the same page, later on they say. Page 17, my lord.
Page?
Page 17.
Page 17.
I hereby remit the punishment to be dismissed from service to be read as compulsorily retired from service.
So this is,
So the punishment was also moderated. And
so you have not challenged this?
my lord, the order is under challenge. This particular order is under challenge.
Which order is under challenge?
25 March 20.
And this is
This
20?
is 25 March then.
Oh,
So initially in the same order, they say dismiss.
okay.
Later on, they say that.
then you write like this. Assailing the impugned order dated 25/3/2020 within bracket annexure 4 to the writ petition, whereby the petitioner was initially awarded the punishment was awarded to be dismissed from service. However, this is by the reviewing authority. However, later on, it was the punishment was remitted to be dismissed, remitted to the effect that the punishment within quotes to be dismissed from service to be read as within bracket to be compulsorily retired from service. Stop. The brief facts of the case is that
Lordship, there is one order of 4th March 2020 and subsequently this 21st April 2020. So Lordship will find that at my annexures of my affidavit, Lordship.
first, I just wanted to put the brief facts. Where do I get the brief facts?
Lordship, in my affidavit.
Give me the page.
Paragraph 4, Lordship.
Paragraph 4.
Yes. Paragraph 3. Yes. Paragraph 3. 3.
It appears that the petitioner has challenged the aforesaid order earlier also it was challenged.
No.
What is this paragraph 3? It reference about some order challenging, then the order says dismissal and all that.
What I see, my lord, is that page 17, it shows, my lord, initially
That is
this
okay,
punishment was recommended by the Assam Rifles Court.
See, the problem is I cannot, now you're not withdrawing. You want this court to dismiss it on merit. If I do not get the brief facts, how can you expect me to author the judgment?
But earlier the commandant had awarded the punishment for dismissal. Page 17 is the order where, my lord, the dismissal was not communicated to me. It has come in the affidavit. But
So where are all these facts?
So where we have indicated is that Birendra Tiwari, the colonel, had earlier recommended after trial dismissal from service, which the brigadier thereafter, while countersigning the same.
One sec, Mr. Pathak, first tell me where do I get the facts in seriatim? Where is your charge sheet? What happened thereafter? Where do I get all these references?
That paragraph 3 of my affidavit, the sequence from the
Your paragraph 3 talks about some other case where it was dismissed. Paragraph 3 at page 65.
No, that is not page 65, Lordship. Affidavit, there are one rejoinder, not the rejoinder, Lordship.
Affidavit in opposition by 1 to 4.
Yes, Lord.
Yes, I've got it. Sorry. Lekha. The brief facts of the case are as follows. Now you give from A to A. It is just facts. Lectures A to A লিখিলো বা 30 লেখে তাৰপিছত লেখা It appears that situated thus, the petitioner filed the instant writ petition seeking directions to quash and set aside the impugned order dated 25/3/2020 awarded by SARC and to reinstate the petitioner in service with all service benefits. Mr. Pathak so-and-so submits that though the petition, that the order of the disciplinary authority awarding dismissal, awarding the penalty of discharge of duty was not communicated to the petitioner. However, upon perusal of the impugned order dated so-and-so, it has come the petitioner has come to know that though the petitioner was initially discharged from duty, however, later on the same was modified to compulsory retirement. Stop. Per contra, MSB Sharma submits that there is no procedural violation or violation of natural justice while conducting the disciplinary proceedings in question. She further submits that the petitioner had committed a grave offense of remaining OSL for 1166 days, and the action taken by the respondent authority is as per Assam Rifles Act 2006, Assam Rifles Rules 2010, and policy in vogue. She further submits that the respondent authorities had provided adequate opportunity to the petitioner at different stages of the disciplinary proceedings, but the petitioner failed to provide any evidence in his support. She further submits that discipline being the bedrock of Assam Rifles, and hence the case of the petitioner, after having been established and proved, cannot be taken leniently. Stop. Heard, perused. Apt to reproduce the relevant paragraphs of the affidavit in opposition filed on behalf of the respondent numbers 1 to 4, paragraph 5 to paragraph 19. It appears that the reading of the aforesaid averments made in the affidavit in opposition filed on behalf of the respondent authorities, it is apparent that the charges leveled against the petitioner having been fully established and proved, the aforesaid impugned penalty of compulsory retirement has been awarded. It further appears that the aforesaid penalty is proportionate to the gravamen of the charge proved. Hence, this court finds no illegality or irregularity in the impugned so-and-so, and accordingly, the writ petition is bereft of any merit whatsoever. Writ petition stands dismissed. All right.
F26. 6, my lord, pertains to promotion. Though the pleadings are complete, my lord, there is still something missing in this matter as far as the policy is concerned. This is a case, my lord, where the dental surgeons in Assam Rifle, they are to be given a time-bound promotion. The first promotion, my lord, from assistant commandant to deputy commandant, as per the RR, it comes on completion of 4 years of service. Then the second promotion to the rank of second in command, it comes after completion of 5 years of service in deputy commandant rank. Now, the grievance here is, my lord, the promotion from assistant commandant to deputy commandant. 4 years service, my lord, of this petitioner was completed on 29/11/2014. So the time-bound promotion was to be considered therein. The recruitment rule, my lord, says that you have to, other than completing this 4 years of service, you have to complete a basic military training.
Basic military training. Other
Other than this 4 years qualifying service, my lord.
Otherwise, you have the 4 years qualified service.
I have the qualification.
But you don't have the military.
The dispute, my lord, here is on that. My lord. The recruitment rule, my lord, at page
What is
66.
the military training? Basic military training.
It says basic combatization training.
Basic?
Combatization training. Now, when this petitioner was appointed, my lord, she was sent for a course which is called a basic military training. The word combatization is not there. It was a basic military.
But will it not mean the same thing?
No, Lordship.
In my understanding, my lord, it means the same. But then later on, what they say, I'll just complete. Later on, they say that no, this is not the course. Your course is a MOBC, basic
But
medical
Mr. Pathak,
officers
at
basic.
the time when you were undergoing this military training,
My lord.
you had undergone military
My lord.
training, right?
My lord.
Or combat? Which one did you undergo?
Military, my lord.
Military. That time the requirement was military training.
No, my lord. The recruitment rule still says basic compensation training.
But why then you...
The word that was used in my training letter, my lord, was military training.
Where is that?
My lord would see that at Annexer 1, page 19.
Yes.
This is the posting, her first posting, my lord. Officer to
Where do I get that?
my lord, firstly and then secondly, Dr. Suman, newly appointed assistant
Completion of basic military training.
my lord.
Yes, your order, Ms. Barua.
Yes, Lordship. Kindly come to my affidavit, Lordship.
Now,
Yes, let Mr. Pathak complete.
One more line. Thereafter, they say that when I claim in 2014, I could not immediately at that point of time raise that issue because the petitioner was on childcare leave. She was on childcare leave. But then subsequently in 2016, they gave her the promotion. I wondered that it should be from 2014 at par with my juniors. Then the reply came that the course that you are required to attend is called MOBC. It is called Medical Officers Basic Course. The word military is missing there again, madam. Now, as to from where this MOBC course originated, my lord, but is a circular. And
That is not mentioned in the affidavit.
It's no mention.
Do you have that information?
Yes, Lordship, as per recruitment rule 2010.
Do you have you had?
Yes,
you
Lordship.
have those copies of the
No,
rules?
this is there. Page 66 of the affidavit, madam.
In our affidavit, Lordship.
Page 66.
Is it mentioned there?
It says basic compensation training, madam.
Yes.
Page 66.
Where is it? Basic combatization training.
It also does not say MOBC.
M-O?
MOBC means Medical Officers Basic Course.
Yes, where is it? MOBC.
This medical officers basic course, as per this rule, that MOBC and come to.
No, but where do we link MOBC to this page 66? I think this is what Mr. Pathak is trying to say. How do you link MOBC to page 66? Your affidavit is silent in that regard. You take for full instruction and let Mr. Pathak know, because I think this is where he is not being he has said that some information are required. I think because he has not understood as how you have linked MOBC to page 66.
Yes.
Correct, Mr. Pathak?
Yes.
So you take instruction, I can have it on another date.
That's
And if there is something, you can file an additional affidavit so that Mr. Pathak knows. Otherwise, he will be taken by way of a surprise. Right?
If they are amending or changing the recruitment rule, there has to be a notification.
Something has to be there, Ms. Sharma. How you have linked MOBC, right? You may know. I will also not know. This court will not know. Neither will the petitioner know unless and until it is communicated, right? So you find out. Should I record this?
Yes, Lordship.
Heard Mr. B. Pathak, Learned Counsel, appearing for the writ petitioner. Also heard Ms. B. Sharma, Learned, you're appearing as, huh?
And as for.
Sorry. As Barua, learned, you're appearing as CGC, learn at CGC. Stop. No. Mr. Pathak draws the attention of this court. Where is that particular statement that MOBC is required?
My lord, it is in my,
No, in their affidavit, I think.
their affidavit, they categorically say.
Page 45.
Page 45.
Para 8.
Page 44.
You are Suman.
Yes.
Mr. B. Pathak draws the attention of the court to the stand taken by the respondent authorities in the affidavit in opposition filed on 12/4/2025 to the effect that the petitioner was not considered in DPC for the was not considered for the promotion of assistant commandant dental surgeon, as she had not cleared MOBC due to childcare leave. However, he submits that no document to indicate that the petitioner is required to clear MOBC is available in the affidavit in opposition. MS Barua, though by referring to the document at page
66. my
it's a
lord.
part of what?
Recruitment rule.
To the recruitment rules enclosed as Annexure J to the affidavit in opposition, tried to impress this court that the aforesaid requirement is stated in which is this is part of what? This chart?
The chart is part of, my lord, the recruitment rules.
1010.
32.
No, but what is this schedule? This schedule is
The
under
schedule is the post and qualification.
in the schedule, comma, a perusal of the same shows that the requirement is only as regards basic combatization training. Let MS Barua so and so seeks a short accommodation to obtain specific instructions as regards the requirement of clearing MOBC. Stop. Prayer is allowed. Relist on such and such data. The date did you?
Nine.
19.5.
This one did you?
My lord, might be too short, my lord.
First week of September.
First. My lord, deeply obliged.
All right.
Item 27.
Yes.
Yeah, please, good lord.
You are Mr. Sahad?
Yes, Lord.
Yes, Mr. Sahad.
Against removal from
Yes.
service. Lordship,
What was the charge?
start with that is, I'm going to the.
Your lordship challenge the appellate order, lordship. Not the dismissal.
All right, let the petitioner submit first.
Charges are at page 35, 6, 7, lot A,
35?
35 to 40, Lordship, and except 3.
Yes, this is the show cause notice.
First show cause
First show
notice,
cause
Lordship.
notice.
Herein, you are hereby required to show cause under Rule 9 of the Assam Services Discipline and Appeal. Read it article. So now charges are number 1, 2 charges.
Yes.
On 23/12/2003, at 2 p.m., complainant Sri Dilip Gogoi is a private informant. Dilip Gogoi, so and so, resident so, lodged an FIR at North Lakhimpur PS to the effect that he appeared in the interview for the post of AB Constable, Assam Police.
So taking bribe. Taking bribe.
Not bribe, Lordship. Not, it is the allegation.
That's right.
that-
I'm trying to understand the
Yes.
charges.
Yes, for arranging a post of police constable, he received 35,000. That is the allegation, Lordship. And on the basis of this, North Lakhimpur PS case number 981, that is Annexure 1, Lordship, that is the FIR.
What happened to the FIR?
Yes, Lordship, that is page 25, Lordship.
No, what happened to the criminal proceedings?
Yes, that terminated. I am acquitted. I am acquitted.
Yes, maybe, but acquittal in criminal cases does not automatically gives you a clean sheet in the disciplinary
Yes,
proceeding.
But
Standard of proofs are different.
it is a purely personal matter.
That
related
we
to
will
filing.
find out, but there appears there are some allegations, not on one occasion, on two occasions.
Lordship.
Right?
Yeah, the authority has discretion.
No, they don't have discretion. The allegation has to be proved.
Proved, yes.
Now, this is a disciplinary proceeding.
Yes.
The standard is preponderance of probability, not beyond reasonable doubt.
No.
Correct? Now,
That
what is the ground of challenge?
is, Lordship. Now,
Is there any procedural violation that you have
yes,
alleged?
Lordship.
What is the
Rule 9
procedural
is
violation?
clearly violated.
Huh?
Rule 9.
Rule 9. What is Rule 9?
Yeah. See?
No, just say it
Rule
in
9,
short. Huh?
procedure for imposing penalties. That is the herein.
So
First-
that means what you're saying is procedural violation is post penalty,
Look.
not for during the departmental proceeding. There is no violation.
Procedure are to be followed. Procedure.
Okay, read.
prescribed herein
Where do
are
I get those?
followed. And
Group
we have-
consent?
we have our decision of our own High Court. Lordship.
We'll go to Mr. Counsels. Why is it so difficult for counsels to first
None.
place the facts of their own case?
Yes.
Decisions you'll place when submissions come. You're not submitting right now. First, clarify the facts.
Yeah. My challenge are number one, that it is complete violation of Rule 9. And I will specifically state that what sub-rules are also violated. Now, Lordship, as per their charges,
Mr. Counsel, I've asked a specific question. What is Rule 9?
Rule 9.
And
Number one.
One second, let the book be given.
Lordship,
You're not even referring to what book you are.
Lordship, there must be definite charge, number one.
Read Rule 9. You give your commentaries later.
Hey.
Read.
Rule, sub-rule 9, Lordship.
Yes, please.
Assam Services Discipline and Appeal Rules 1964.
Read.
Yes, Lordship. Record of inquiry shall include, that is the charges framed against the government servant.
Are you not reading Rule 9?
Rule 9, sub-rule 8, Lordship. Sub-rule 8.
Sub-rule 8. Okay.
8.
Read.
Lordship. The record of inquiry shall include, number one, the charges framed against the government servant and the statement of allegation furnished to him. Number two, his written statement. Then three, the oral evidence taken in course of inquiry. Then the documentary evidence considered in course of inquiry. The orders, if any, made by the disciplinary authority and the inquiring authority in regard to the inquiry, and that is very much important. 5, a report setting out the findings on each charge and the reasons thereof. Then 9, if the disciplinary authority,
Yes, I've seen this. So that is the record of inquiry.
record of inquiry,
Yes.
that is.
Ah.
Now,
And then in your case, the
Yes.
disciplinary authority and the inquiring authority is the same or are different?
different.
Different.
Because it is the inquiry authority is to inquire and submit this.
No, no.
report.
Who is the inquiring authority?
They have appointed the additional superintendent of police.
1 second.
Additional superintendent of police, not Lotipur.
Inquiry authority is one. Additional.
Superintendent of police, not Lotipur. He is the inquiring authority.
And who is the disciplinary authority?
DIG. Deputy Inspector.
DIG.
Law.
Yes.
There.
Now, according to you, this record of record of inquiry was not maintained.
Not.
Where do I get the record of inquiry?
Yeah.
And what is the prejudice that has been caused to
Yes,
you
Lord.
because of this?
Lord.
Because has the disciplinary authority not agreed with the inquiry officer? He's agreed.
There is no such finding, different finding, whether how the disciplinary authority concurred with the findings of the inquiry authority.
Because Rule 9 says the disciplinary authority shall, if it is not the inquiring authority, consider the record of inquiry
Lord.
and record its finding on each charge.
Each
So
charge.
according to you, this is not done.
Not done, Lordship.
Yes. Is it correct?
Kindly see that he challenge first, he challenged the.
We'll come to the challenge later.
Challenge the
We'll come to the challenge later. I am yet to hear you all both properly. But as far as the record of inquiry, where is the record of inquiry?
The record has come, Lordship.
Have you checked?
Not, I'm not gone to the.
So you can have a look at it. I'll have it on another date.
Lordship, or 2 weeks, Lordship.
Not 2 weeks, next week. You have a look at the records of inquiry, find out if the reasons, if sub rule 8 of rule 9 is followed, not followed. Secondly, if followed, if, the disciplinary authority's order, what findings against these charges have been recorded, where do we get all that? Find out. You have a look at the records.
Just now received the record.
All right. Heard, Mr.
Yes, sir.
So and so, learned counsel for the petitioner, heard Mr. So, also heard Mr. So and so, learned counsel for the respondent. Mr. So and so submits that the records have been received, since the records have been received only today morning, he could not go through the same and accordingly seeks a short accommodation. Yes, when? Next week?
Next week, maybe.
Relist next week on a date to be fixed by the registry. Ekhon loi lobo.
Item number 28.
Termination.
Yes.
Yes.
Work charge employee.
Huh?
Work charge employee.
Who's appearing for the respondents?
Lordship, this is the third round of litigation. She is seeking for re-engagement as a work charge employee in the DC office in terms of order of the first round of litigation, and there is a circular of the Ministry of Finance. Both of the authorities she is relying upon. First, Lordship will have a look
Right now, the prayer in this week is the re-engagement at the DC office.
Re-engage.
Yes.
Lordship will have a look at the order in the first round, page 53. Facts is also mentioned in that order. Page 53, Annexure 12.
Yes.
Heard so and so by filing this petition under Article 226 of the Constitution of India, petitioner seeks a direction to the respondents to re-engage her in service. Case of the petitioner is that she was working as data entry operator in the office of the
same prayer.
Same prayer. Facts will be available here, Lordship.
Okay, no, but otherwise it's the same prayer, no?
Same prayer.
Re-engagement of service.
They were directed to consider. They rejected by
Okay. All right. Read.
On contractual basis since 1994. However, her contractual engagement was continued without any break. After rendering service as data entry operator for 15 years, on the instruction of higher authority, petitioner was shifted to the office of Senior Sub-Register Guwahati in the year 2009. After rendering service there for about...
Slow, Mr. Counsel.
May I read it again, Lordship?
It's okay. Just read slowly.
After rendering service as data entry operator for 15 years, On the instruction of higher authority, petitioner was shifted to the office of the Senior Sub-Registrar, Guwahati, in the year 2009. After rendering service there for about 3 years, on 7/7/2012, she was released from her service with effect from 30/6/2012, along with some other employees working in the office of the Senior Sub-Registrar, Guwahati. Aggrieved petitioner has filed a writ petition seeking the relief as above. Lordship will then have a look at the operative portion, next page 55.
Page
55, next page. It starts with having regard. Last paragraph. Operative portion, the
Yeah.
direction.
Yes.
Having regard to the above and considering the fact that service of the petitioner was utilized by the DC Kamrup Metro for more than 15 years before shifting her to the office of the Senior Sub-Registrar, where also she rendered service, the Deputy Commissioner is directed to consider re-engagement of the petitioner in his establishment by taking all relevant factors into consideration, including the earlier recommendations made. The Deputy Commissioner shall also take into consideration the claim of the petitioner that similarly situated persons appointed with her are still working in the land record branch. Then, Lordship, they have passed an order that your Lordship will find at
So basically consideration for regularization.
not regular
Re-engagement.
re-engagement. My prayer pleadings is very specific. I am not claiming for regularization. Now, thereafter, this is the third round of litigation. Thereafter,
So you were disengaged.
I was disengaged, and there is an order to that effect. I was disengaged by order at page 38. That was challenged in the first round of litigation. And then, Lordship, they have, pursuant to this order of this Honorable Court, they have passed an order that is at page 65. Page 65. Unfortunately,
Page
65.
Yes.
65. Unfortunately, Lordship, by this order, they have wrongly considered me for regularization. However, that was never my prayer. By this
So
order,
this page 65 is after the order of this court.
after. They have wrongly considered me for regularization. Page 66, Lordship will see. 66, operative portion. Last 3 lines. Now,
Yes.
after careful examination of facts and records available in this establishment, it is observed that case of the petitioner, Srimati Nadima Begum, is not covered by OM dated 27/6/2013. Now, this 27/6/2013, that OM I have enclosed, that is an OM regarding regularization, not
Which page?
that is at page 67.
Okay.
67.
Okay.
This is a OM regarding regularization, not re-engagement. Rather, there is another OM which is on regularization, re-engagement.
That was not considered.
That was 69 page. This is on which I am relying upon. 69.
Yes.
Absolutely, I am covered by this one. Page 69. Ban on engagement. 30.
So are you challenging this order here? The 27 June?
This order was challenged in the second round.
Okay.
In the second round, ultimately, they were again directed.
All right. Page 69, just show me page 69.
69.
Yes.
69.
Yes.
Ministry of Finance.
Yes.
30/10/2001.
Yes.
Ban on engagement of MRC-WC employees engaged after 1/4/1993.
Yes.
Government have examined the question of continuation of master role workers, work charge employees engaged after 1/4/93 who have completed 5 years of continuous service pursuant to the order of Guwahati High Court in so and so. Now, this paragraph is next paragraph is relevant, Lordship. After a careful consideration of all the aspects, it has been decided decided that the MRW/WC employees who were engaged after 1/4/93 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in their respective capacities subject to proper verification of their engagement by the respective appointing authorities. Then next paragraph, not much relevant. Then second last paragraph. In implementing the above decision, the appointing authorities are also Also to terminate the service of those MRW/WC employees who have not completed 5 years of service as on 24/1/2001.
Yes.
Now, as per the order of in the first round itself, it is recorded I have completed 15 years. Then for a moment, Lordship will have to look at page 33. 33.
No, what did this say? In implementing the above decision, the appointing authorities are also to terminate the service of those so and so who have not completed 5 years of service on so and so.
Condition is that, Lordship.
That you have done.
I have complied, I have fulfilled this condition. I fulfilled this condition because I was engaged after 1493 and
You were engaged after 1493.
1490. I was engaged on 19/9/94.
1994.
94. And I was released on 36/2012.
Released
36/2012. That is at page
on
38. 06.
Yes.
2012.
Page.
Page 38.
And the engagement is at page?
Engagement 33. 33.
Yes.
Page 33. Here it says one who has completed 5 years between 1493 to 24/1/2001.
So that you have.
That I have. Then, Lordship, relying on these circulars, I have challenged the order that your Lordship had pointed out, 16/6/2016. I had challenged by writ petition at page 73. I have enclosed the writ petition also in the second round of litigation just to show that my prayer was not for regularization.
Where is the order?
Order, there was a mistake in the order. That's why I prefer writ appeal. The order of the single judge, page 90, page 90.
Yes.
Here also what happened, Lordship, in the first paragraph, Lordship will see 91.
Yes.
91.
Yes.
Heard PP Dr. Learned Counsel for the petition who has filed a petition for a direction to re-engage her as grade 3 or in any other similar post in the office of DC.
Yes.
Second paragraph also, fourth line re-engagement.
Yes.
Last paragraph, somehow, Lordship, it was directed that she has no claim for regularization and the writ petition was dismissed. Paragraph 4 and 5. And ultimately, paragraph 6, writ petition was
You filed an appeal against?
I filed an appeal. Court directed to consider in terms of this circular, which now I have read, Lordship, 2000.
Re-engagement circular.
Re-engagement
Where is that order?
Division bench order, page
93. 93. It starts 94.
Starts 94.
Yes.
Operative 95.
From the records, let's read from there, 94.
I am reading third paragraph. May I read 34, Lordship? 94,
Yes,
third
yes,
paragraph.
yes, third paragraph. From the
Learned
records.
Counsel.
Okay. All right, you can read from there.
Learned Counsel for the writ appeal and writ petitioner submits that although the prayer in the writ petition was for re-engagement of the writ appellant, writ petitioner as a work charge employee, the writ petition was dismissed by the learned single judge, holding that the petitioner could not be regularized in service since he was not working in sanction post. So all these sanction posts, all these criteria are for regularization. Then last line, Lordship will see, next paragraph, last line, main prayer in the writ petition was also for re-engagement.
Yes, please read.
Yes.
No, that from the record.
From the records and the averment made in the writ petition, it appears that the writ petition writ appellant was working as work charge employee in the office of the DC Kamrup. Since the service of the petitioner was discontinued by order dated so-and-so passed by DC, she was constrained to file writ petition before this court challenging aforesaid order so-and-so. Appears that main prayer in the writ petition was also for re-engagement of the petitioner and not for regularization in service. Lordship may come to the operative portion.
Yes.
95.
Then go by learned counsel of the respondent. Let's finish it.
I'm reading.
Why are you not reading the whole order?
I'm reading.
You want Mr. Chutia to point out something from the order?
Nothing, Lordship.
Then read.
Yes. Learned counsel for the respondent would, however, argue that as per office memorandum dated 30/10/2001, issued by the Finance Department, Government of Assam, there are certain conditions and procedures to be followed before re-engagement of a worker casual employee, and although there is presently not a ban on re-engagement, but re-engagement can only be done by following the due procedure as enumerated in the aforesaid OM dated 30/10/2001.
This is that OM.
Yes. This is in my favor only. Yes, he has further submitted that since the petitioner's limited prayer is for re-engagement, her case may be considered for re-engagement in terms of the aforesaid OM. Although we do not find any merit in the writ appeal as to the regularization of the petitioner, and we are completely in agreement with the finding of learned single judge on this aspect. Here, Lordship, I pause for a moment. There was no prayer, in fact, for regularization. Writ petition also I enforced.
All right.
Then, yet since the aspect of re-engagement was not being considered by the learned single judge, and since there is already an OM dated 30/10/2001, which provides for re-engagement of workers, casual ad hoc employees, subject to fulfillment of certain conditions, we dispose of the writ appeal with the direction to the state respondents to consider the case of the writ appellant, writ petitioner, for re-engagement in the office of the DC Kamrup Metro in her earlier capacity in accordance with law presently in force, including the OM dated 31/2001. In case the writ appellant, writ petitioner moves an application for re-engagement, we make it clear that dismissal will not come in the way. Then writ petitioner will be at liberty to make prayer before.
Dismissal of writ petition.
Yes, and dismiss. We make it clear that dismissal of the writ petition filed by the writ appellant, writ petitioner will not come in the way in case the writ appellant, writ petitioner moves an application for re-engagement. The writ appellant, writ petitioner will be at liberty to make a prayer before the authority for her re-engagement in accordance with law, including OM dated 30/10/2001. She submitted representation. It was not considered. Then she filed contempt petition. In the contempt petition, the court had fixed the time limit. Since in the petition,
Where is that representation?
page 97.
Yes.
She communicated the order and filed the application as per the order of the division.
And the contempt?
A contempt order 99. Court had fixed a time limit of 3 months.
Then what happened?
Okay. It communicated that order also. And ultimately, the final rejection order was passed.
Where?
105. I am challenging this order in this particular.
105.
Here they again say, Lordship, they come back to their. I am reading this order.
Yes, please.
Page 105.
Yes.
Yes. In view of the subject and letters cited under reference, I would like to inform you that the records available in this establishment do not corroborate your claim of continuously working in this office or in the office of sub-register for a period of 5 years or more. As such, your petition cannot.
This is on merit.
Yes, merit.
They said that there is no record to show that 5 years continuation appointment you have,
Yes.
which is a condition precedent to be to get the benefit of that office memorandum.
Yes. Now, Lordship will
Correct.
have, yes.
Now,
Lordship will have a look at the order in the of the single judge. First order, Lordship.
No, before we go to that, because ultimately the records, Mr. Chitya, you have filed your affidavit
Yes,
here.
we have filed affidavit, my lord. As per our affidavit, she was not engaged as a workers employee or master of lovely. She was engaged as a piecework basis, because at that moment, piece work basis.
So whenever
There is some work you do
so you mean to say whenever necessary?
Whenever necessary, yes, SOS. So at that moment,
So the continuity was not there.
Not there, my lord. In that moment, my lord, what happened when?
Which paragraph in your affidavit?
We have filed affidavit, my lord.
Where?
It was lordship can go through it.
Affidavit in opposition by R4.
R4.
Paragraph?
Paragraph 7, lordship can see. Paragraph 6 starting.
Yes.
The opponent begs to state that as per available office records, Srimati Nazima Begum along with 5 others were engaged temporarily on piecework basis and not appointed against any sanctioned post. Hence, the authority reserves the rights to terminate such engagement as and when deemed appropriate without assigning any reason thereof. Paragraph 7. The begs to state that the deponent state that the same are matters of record, but the deponent does not admit anything contrary to record. The deponent denies the claim made by the petitioner that she was engaged in daily wage basis. Her engagement was on piecework basis, which is not covered under MR
master workers or workers. As such, the engagement is done for completion of a specific work. There is no scope of re-engagement after the said work is completed. Specific work means, Lordship, at that moment, when computer came, all the documents of the officers, they all are scan and put to the computer. That was the specific scheme and specific work, that piece work. They were engaged employee. And so far, they are only for this purpose. This scheme has now come to an end, so they have no right to be continue in the office. So I can rely on the case law, my lord, 2009 6 FCC, my lord. Yes, yes, I am reading, my lord, regulation entitled to staff employees.
No, not regularization.
No, not regulation, my lord.
This is not a case of regularization, so let's not have any decisions of regularization.
No, not
Now, the only question is whether this person was continuously working 5 years or not.
No,
That is the only consideration.
No.
Yes, page 33, which is that engagement?
33.
33.
But when necessary, somewhere register office, somewhere in the master.
Mr. Chutia, please come to page 33.
Page 30.
This is the engagement
Yes,
letter, right?
Yes, sir.
Do you have anything else, or this is the only one, Mr. Chutia? Because this says
only because
Ganesh Burman designation data entry operator.
Yes,
Date of engagement 19/9/94. And this was given signed on 7/7/4, right?
Yes.
Present status working till date.
Yes.
So this is there. Now, if you can, now where is that 37?
I am serial number 3.
That means it is issued 7/7/2004.
Yes.
But
Now, if you come to 37, for smooth functioning of the marriage, shows that the following
they are not working continuously.
I require lordship only 5 years, sir.
So you, see, what I'm trying to tell you, Mr. Chutia, is that the affidavit seems to be a bit vague.
Yes.
You see, I have understood. They are saying I'm entitled under this office memorandum, and it is re-engagement, not regularized. This is the third round of litigation. The division bench has very clearly said that though the court do not agree that he is entitled for a regularization, but as it appears, there is an office memorandum. Under the office memorandum, if the conditions are fulfilled, then the petitioner is entitled for a re-engagement, correct?
Yes.
Now the question is whether the petitioner fulfills the
5 years or not.
condition.
Yes.
Now you are trying to impress the court, no, this job was peaceful, correct? Now for that you have to show something more.
Say records. In the I would bring the records.
Get me the records.
Whether continuously or not.
You see, if you can show from the records that it is only piecework and not a continuous engagement, then perhaps you may have a case.
I got the point, my lord. Yes, sir.
All right.
And
Yes.
may I submit one small thing, lordship? There is actually a release order also.
That's
They have
okay.
released me on a particular date, meaning thereby lordship feel that.
We will continue with the hearing. I think I can fix it for further hearing. I have
Lordship
record, lordship, this will perhaps be the 4th date, lordship. Records were directed to be produced.
Mr. Counsel, I'm keeping it as part heard. So I will ensure that if the records do not come on the next date, personal appearance of the hearing officer.
Yes, yes.
I think that would take care. Heard, Mr.
GJ Sharma, Lord.
So and so, learned counsel of the learned counsel for the petitioner, also heard Mr. T.C. Chutia, learned additional senior government advocate for the state respondents. During the course of hearing, the learned so and so appearing for the petitioner has concluded his hearing, concluded his argument. During the course of argument by Mr. So and so, it appears that the records pertaining to the issue involved in the writ petition is essential. Let the records be made available before this court on the next date of hearing. List on so and so for further hearing. Part heard. You will get your right to reply. Don't worry.
Concluded.
Huh?
That word concluded may not.
Your argument. You have a right to reply, Mr. Counsel. Huh?
I'm obliged.
Are you not the petitioner lawyer?
I'm obliged.
26th of August. Yes. You, Mr. Chotia, I think the issue is very short. So you focus on the records and you indicate. If you want to show that it is piecemeal work, then show us.
Yes, definitely.
And also I want to see where is the engagement letter.
Yes.
That document is not an engagement letter.
I cannot say, Malad, this like it is continuing, Malad.
Because what is the terms of his engagement?
Engagement.
If you have engaged
It's
him
not mentioned
and
here.
you have not released, then just because on Monday you don't utilize his service, you cannot say he is not working continuously.
Yes.
So everything would also depend on the engagement. So you have everything, huh?
Next,
Okay. Item 30.
Compulsory retirement. This is
From my learned within change, my lord. I am raising a preliminary objection about the filing of the additional affidavit, my lord.
No, I will
Just to
confine
fill up,
the-
just to fill up the
Huh?
lacuna, my lord.
I'll fill up I will continue, I will maintain my arguments on the basis of the evidence
Okay,
and
done.
materials already on record.
an additional affidavit has been filed.
Fine, my lord. But
You are not going to rely upon it.
No, that is for whether to say, only I reiterated the other charges as to how it is not based on the records. From the records, I will show, my lord, because they have given.
No, but Mr. Das, what is your objection to the additional affidavit?
Because
Any new claim or anything? Huh?
in the additional affidavit, they have raised that about that ground, my lord, perversity, my lord. In the original episode, there is no any.
There was no such ground.
My lord.
There was no ground.
No, my lord. And my lord, and this and drawing your lordship attention to order, my lord.
Mr.
17/6, 2015, my lord.
Sorry?
Order date 30/5, 2025, my lord.
Mr. Chalia, in case there is an additional new ground, then of course,
No new ground.
because Mr. Das says perversity has been argued for the first time in the additional affidavit.
That was not there in the original petition or
I will
in the
confine my
additional
arguments to the materials on record, whatever is produced by me and by my
Mr.
friend.
Das, even if suppose they are taking this ground, the matter has not started for hearing.
Right.
So if you want, you file your response. Because you see, we don't know, once we start with the hearing, it might be so that this court may have to go into the additional affidavit because maybe certain clarifications have been brought by way of the additional affidavit. So this court can always go into it. This is not, the hearing has not started.
Yes. Can be filed only with the permission of the court, my lord.
So this court will accept it.
They
They have filed it.
only, my lord, just
They are filing it to assist the court. So this court, because you see, in the middle of the hearing, I would not have allowed. Unless and of course the court wanted some clarification. But before the hearing started, an additional affidavit has been filed.
No, only matter. I am drawing your lordship attention order date 35/2025, my lord. By the
One second. Which order? Which order?
30/2025, my lord. Readings are completed, my lord.
One second, I am not being able to locate this order. 35. There are so many orders. 35.
25.
25.
This is not a pleading.
Mr. Chalia, how can the additional affidavit be not a pleading? What is it then, Mr. Chalia?
No new thing has come in, Milan.
No.
That's why, Milan.
Mr. Das is trying to show something. Let me have a look at it.
That I know that.
All right.
I know this.
Yes, it is submitted that the pleadings in the matter are completed. Therefore, the matter requires for extensive hearing. All right, but if they have filed subsequently something, you see, this court is liberal as far as pleadings are concerned. So I am going to accept this additional affidavit. Now, it is your option. You want to file something, that is your option. I will later on not give you any time. I'm making it very clear. Later on, I'm not giving time.
We are not going to file any.
All right. So then I am accepting this affidavit. With that understanding, we shall now proceed. Okay. Yes, Mr. Chalia.
Yes, I have already stated, as your lordship has seen, the charges I'll go directly, I will go to the charges one by one. And to show how I am.
Which page, Mr. Chalia?
That's from page 28. Or.
Yes.
Yes. Or the details one, if your lordship's one, then. No, that is the one. The charge amount one. It says that.
The petitioner was serving as what?
Deputy manager.
Deputy manager.
Deputy general manager.
General manager at which, what was the?
At Fulbari.
Fulbari Garo Hills.
Garo Hills.
This is under, this is what organization?
Power grid.
Huh? Power grid. Okay. Yes.
There it is alleged that on that, during that period.
You read.
That. Three.
Mr. Cholia, let us start from 26. It'll easier because the articles are summed up here. Let us read that. Because you see, this court is not going to go into all this so much. This court will only see whether
yes, on the basis of that, I will show
whether number one, what the charges are. Number two, whether the natural justice and everything is met or not, and then how the punishment was awarded, whether the penalty is listed penalty, not listed penalty, all that. The rest, whether there was sufficient evidence, not sufficient evidence, that the court is not going to go into all that. Yes.
It says H.K. Phukan, the prisoner, was posted at Fulbari under NRCP Yan 2618. During his posting at Fulbari, he was looking after the construction work of Fulbari substation, and Srimati Nijomoni Gogoi, his wife, received rupees Iman through her bank account during bearing Iman of the State Bank of India 6 Mile branch. From Sujya Soikia, a labor contractor engaged by NESCOM towards hiring charges of an excavator owned by her, Sri Phukan resorted to business with the working contractor under his control and misused his official position for personal gain. Here the allegation is that I engaged my wife for
all right.
contract.
Next allegation.
Phukan thus failed to maintain this absolute integrity in a manner which is unbecoming or possible, misused his official position, acted in a manner prejudicial to the interest of the company, and violated non-complied with the company's rules and other things. Then number two.
Yes.
H.K. Phukan, while posted at Fulbari under NRCP project, deliberately concealed the fact of acquiring 2 JCBs by his wife for Iman and Iman, purchased on Iman, and rupees Iman purchased on Iman, while submitting his annual property returns, the ending Iman and Iman 2015 and 17 respectively. Further, H.K. Phukan did not give any intimation as per CDA rules 16 while acquiring both these JCBs. Sri Phukan thus failed to maintain absolute integrity, acted in a manner which is unbecoming of a public servant, acted in a manner prejudicial to the interests of the company, violated or non-complied with the company's rules, procedures, and failed to report transactions concerning movable property by the above act and omission. Then number 3. Sri Phukan, while posted at Fulbari under Iman Project 2-3 R bills dated Iman without taking measurement of artwork with respect to the site leveling work of
132-33 kV.
kV Fulbari substation, and undue benefit has been extended to the contractor. Thus, Sri Phukan has abused his official position to pass on undue favor to the contractor by way of paying an undue amount of rupees demand 1,000 only, and thus failed to maintain his absolute integrity and acted in a manner which is unbecoming of public servant. That's number 4. Then number 4. while posted at Fulbury, processed 2 and 3 bills on the same day, that is Iman and Iman, for respectively to authorize the bill for payment within his power of delegation as per power grid DOP.
So basically abuse and misuse of his power. This is the allegation.
Yes.
By favoring some
Yes.
contractors with the help of his wife.
Favoring is one.
For benefiting his
the other.
wife. That is in short.
Yes.
Yes. Now
I will go to the details here. And for number 1, your court will say that what is the allegation there?
any list of dates or anything is being prepared by any of the parties?
I have given one written submission of the case, Miller. They are given my submissions.
Yes. Why there is a bill enclosed to the written submission?
Where? No, bill, those 2 bills, Miller, where
They are part of the
yes,
pleading?
for the charge. Charge number 4.
What are these two? You have you received a copy of the written arguments? In the written arguments, these annexures are there or not? The 2 RA bill?
Yes, I've given. In charge number 4.
That was not included in the repeat or the repeat Miller.
They're not there.
No, that was not there.
What are these bills?
It is from the only for claim. No, these 2 bills, I take your lordship to number 4.
Mr. Chalia, these bills are enclosed to the writ petition or not?
They were referred to in the petition.
They were referred.
Referred to.
But they referred but not enclosed. How can the court take this cognizance into these bills, Mr. Chalia? You wanted to refer to them, you should have enclosed it.
Without referring to the bills also, your lordship can.
Very well. You see, I am not on the question I shall refer, I shall not refer. I shall definitely do whatever I must do in accordance with law. But if you want to refer, if you want to place a document, that document has to be firstly part of the record. Now, this is not the way that documents are handed before the court by way of some written submission.
Part of the record at the hands of the
Part of the records?
in the hands of the petitioner. Yes.
You mean that they are part of the records that are in the office of the power grid?
Yes, no.
But this is not the way it comes to the record of the court, Mr. Counsel, Mr. Senior Counsel. This is not how it comes to the record of the court, correct? You may say you may say that the records of the power grid in connection with the case would be required. We can have a look at the records and we can see whatever documents are available. That is one way of looking into the records. Correct. Now, secondly, if you want to rely upon a document, that document must be brought in a manner which is befitting. This is not the way the record, the documents are placed before the court by way of some written submission. I'm sorry, but it seems that a lot of things are
not
correct. I don't mean it to you, Mr. Chalia, but this is not the way.
That has come from the blue.
It's not the way. This is. I'm sorry, Mr. Chalia. I do not approve. I do not approve the manner and way this document has been placed before this court by way of written submissions.
This is part of Article 4, Charge 4.
It may be part of Charge 4, but it is not enclosed to the writ proceedings, Mr. Chalia. Please try and understand what the court is trying to tell you. It is not part of your enclosed documents.
It is.
You see, Mr. Chalia, because you people are the custodian of this court. Now, you see, if such in this manner documents are brought up before the court by way of written submissions, what is the requirement of enclosing any documents to the writ proceeding?
Page 39.
Reference could be there, Mr. Chalia. Reference, you may refer to a lot many things in the writ petition. Please understand what the court is saying. Is there any difficulty to understand? Please understand, Mr. Chalya. I'm requesting you to understand what the court is trying to tell you. This is not the manner that you bring documents. You want to rely, you can file an additional affidavit, bring it on record, there is no problem. And if there are documents available in the record of the power grid, you can always ask them to produce the records. But these two bills are enclosed to the written submission, and they are not enclosed and annexures of the writ proceedings. Isn't it, Mr. Das? Please, is this the manner which documents are brought?
You may refer to page 32 of my petition, of the writ. Page 32.
Yes, page 32 is an article. Mr. Chalya, I am understanding what you are saying. You mean to say that these bills have been referred here?
Yes.
Reference of the bills here doesn't mean you bring those bills by way of your written submission. Please understand what the court is saying. That is why I said, please understand what the court is trying to tell you. Because you all are setting examples. Juniors are going to follow what examples the seniors places before the court. Please try and understand what the court is trying to tell you, Mr. Chalya. Because you see, what I'm trying to tell is for the interest of the institution, Mr. Chalya, not for this case. Mr. Chalya, what I'm trying to tell you is for the interest of the institution, not for this specific case.
I have done enough, Milord.
No, but
55 years
please
I have done it.
understand what I'm trying to tell you.
I
Please understand what I'm trying to tell you.
am at the sunset.
No, Mr. Chalya, I'm sorry, but this is not the way this should have been placed.
No,
Anyway,
that is not a fact that way, Milord. Here, regarding, I will go to the written submission directly. And there I have said the statements of imputations from misconduct of Article 1 is that the petitioner has engaged the deputy general manager, Pulbari, while executing an ERCP work executed by NICOM. His wife, Nisuponi Gogoi, through her bank account received from Sujya Saikia, a labor contractor engaged by the main contractor, received that money, and it was further stated that amount was paid to his wife towards the higher charges of JCBs owned by his wife, and petitioner has resorted to business. Here, petitioner's wife has not got any contract, because I have clarified the contract work of hiring the JCBs belonging to wife is utilized in work.
Where is the inquiry report?
Oh, 41.
Yes. You can skip the introduction.
Yes.
Come to the findings. I think paragraph page 46, evidence is adduced. Yes.
Gentlemen, my lord, page 51, my lord. Conclusion and findings, my lord.
No, 46 is evidence. From there,
You will see from 46. Yes, Mr. Chalya,
during
46.
execution of the work under packaging NESCOM, executing agency had engaged Sujya Saikia as subcontractor who further deployed the
Where are you reading, Mr. Chalya?
towards middle.
No, you start from 4.1. During the
4.1.
course of inquiry.
During the course of inquiry, documents listed in Annex 3 of the charges were not disputed and were as such taken on record. The inquiry marked as exhibits 1D to D1 to D30. One more document was produced by PO, which was marked as D31. 6 witnesses on behalf of the management were examined, and 3 witnesses were examined on behalf of the CO as defense witnesses. PO, in his written brief, that is Iman has argued that all the charges framed against the CO has been proved, and in basis of the evidence adduced during the course of inquiry, the arguments of the PO as article in brief as summarized below. The CO was posted at Fulbury, November 16, and site changed the following packages on RCP, NECOM, Infra, then during the execution of the work under package Iman, NECOM executing agency has engaged Suzuki as a subcontractor who further deployed the excavator at site, which was owned by Nizumani Goi, wife of Sri Fukan. He has not engaged, he engaged a subcontractor.
Mr. Chalia, just read.
This was confirmed by Sucha Soikia, who also admitted to have transferred the amount of Iman to the account of Iman of Nizumani Soikia. This bank account of his bank, this CEO has thus resorted to business through his wife with working contractor under his control, thus misused official position in the for his personal gain. Here, the PO has evidence of one has been produced and others have not been produced. I will go to the others also by your reference.
Mr. Chalia, I'm only trying to understand the facts.
No, that's true.
Could you please assist the court to understand the facts and just read the inquiry? You may give your submissions later on.
Gogoi wife CEO had purchased an art excavator on dated Iman for Iman from Uja, Guwahati. The CEO had made payments of rupees 7,000 for this art excavator, and the remaining amount was taken as loan from Sri Equipments head office, Calcutta, but he did not inform the department about the acquisition of the art excavator, which was required to be intimated within 1 month of the date of transaction, and also the annual property return of for the year ending 2015. Srimati Nizumani Gogoi, wife of CEO, purchased another art excavator of rupees Iman from Uza Art Movers, Guwahati. The down payment of rupees Iman was made by the CEO, while the remaining amount of Iman was arranged as loan from Siman. The CEO stood as a guarantor of the said loan. No intimation of acquisition of the money was given to the department, as is apparent from the annual report of the year 2017. Then number 3, the CEO submitted second RA bill by Iman, IOM reference, no number NRC dated Iman on 29/6/2017 for rupees Iman towards the work package of Iman. The invoice of the said bill was prepared by the executing agency on 31/5/2017, and no calculation sheet for joint measurement certificate was attached with the bill. Similarly, CEO submitted third RA bill dated Iman for the amount of Iman, and this RA bill was also not supported by calculation sheet and joint measurement certificate. The quantity of excavation and filling was done on as Iman cubic meters in the second RA bill, and in the third RA bill, the quantity of excavation and filling was shown as Iman, which jointly comes to 19,000 cubic meters. However, as per the calculation sheet prepared by NICOM, the total quantity of art cutting Iman and the
Nijumani Gogoi is the wife?
Yes.
Yes, read.
However, the payment was released for 19,000 cubic meters. After deduction, the finance department Power Grid Guwahati released the payment against RA bill Iman and Iman for RA bill 3 after deduction. During inspection by Vigilance Department, it was observed that the quantity of cutting and filling has been taken separately, whereas the same should have been taken either by cutting or filling, whichever is higher. On the basis of this observation, rechecking of the cutting and filling measurement was done by Iman, and during the measurement, the quantity of cutting was found to be Iman cubic meter, and the filling of volume was found to be Iman cubic meter. Based upon the observation, the process of recovery of the amount of refund was excess payment of rupees Iman was initiated, and the competent authority approved recovery of this amount from the contractor. The additional document that exhibit Iman is pertinent to the standard technical qualification of site leveling and art cutting referred to in Iman specifics only. Excavation should be measured for payment purpose. In view of this, payment of cutting and filling, whichever is higher, is required to be made, and as has been clarified by Bhaskar Roy, DGM Vigilance. The CO thus committed gross misconduct and caused undue favor to the contractor by paying him towards the art cutting work for which the contractor was not entitled. But the vigilance observation, the excess payment would not have been deducted from the contractor, would have been illegally benefited. Then 4.5. The vouchers of RA Bill 2 and 3 were generated by Sri Suresh Kumar Sharma on behalf of NICOM, and according to him, he signed no signed copy of the joint measurement certificate was available with the office, and the quantities as mentioned in the invoices were based upon telephonic information received from the site. Sri Chakraborty, engineer, who signed the RA bills on behalf of NICOM on 29/6/17, stated that inquiry that he signed these bills at the instance of Fukon CO, which visited NICOM office in Guwahati on the said date, along with Sri Chanchal Sangma, and asked him to sign the bills, which he signed without making any query. Sri Chanchal Sangma also stated that during inquiry that no physical joint measurement of certificates were submitted along with said RA bills. Thus, both the bills were prepared on the same date, and considering the total amount of these two bills, CO was not authorized to release payment as per delegation of power of the debtor demand. The section 4 is provided against the CO. The CO in his written argument then is that the wife Nitumani was doing business of her own in her own capacity with the mutual understanding with the brother Pramod Gogoi. According to him, the said GCB purchased by her wife let out to Ramsagar Prasad as per agreement Exhibit DD, who was utilizing the vehicle, and the CO has no involvement in this business in any way. As regards the second JCB purchase demand, CO has stated that the same was given to Sirajul Islam by the agreement that the demand the are good according to the position of Sujya Soitia, DW1. This is important. A labor contractor engaged by NICOM for construction work at Fulbari site had three archivators, and cutting work at site was completed on Iman, but filling work could not be completed due to the start of the work by other contractor, and the local villagers stopped the work due to road problem. That there was no art excavator available at site, and therefore Sujya Saikia discussed with his site in charge Abhijit Borgohain, who further discussed it with Sirajul Islam, who took the JCB to the site on higher basis. So under these circumstances, Abhijit Borgohain took the JCB to the site on higher basis. So under these circumstances, Abhijit Borgohain used the vehicles at Fulbari site.
All right, Mr. Chalia, we'll
yes.
resume
Yes.
after break.
Yes.
Mr. Das. Okay, I think this one after will take time. We'll call you. Mati Dibo. Mati Dibo, little louder. Yes, Mr. Chalia.
Yes. I was reading at page 49 as well.
Yes. Yes.
In Article 2. Article 1, I have finished that. CO admitted that his JCB purchase was purchased on Iman, and make payment of 7 lakhs, including down payment of 7 lakhs by him. He's pleased that he did not inform the department about the property, as he was not aware that provisional subsidy of the rules of the project. He came to know about the requirements on December 17, and he immediately initiated his acquisition of JCB by his wife India and his wife in the property return of the year 2015, and he had no mala fide intention to conceal the same. As regards the acquisition of the same, the second JCB in 2017 by his wife, the CEO argued that there was delay in registration of the vehicle with the transport authority and the materialization, and which materialized on May 18, and hence the did not mention that this property return in the property return 17, which was later initiated in the property return of 2018. Then 3. The CEO has argued that the Fulbury site works were awarded to the corporate center, and till his posting at Fulbury site, the technical specifications relating to his contract were not available at the site, and as such, he followed general technical specifications, which were in no details about the leveling work and was specified. In such a situation, there was no need to raise query to the engineering department.
It appears, I'm sorry, I'm cutting you
yes,
short,
yes,
Mr. Chalya.
Yes.
But I have read it. I was reading it a bit fast. So looks like that with reasons the inquiry officer have said that the allegations have been proved, right? Now the sufficiency of these evidences this court cannot go into.
No, sufficiency is different, Milon, because he has not discussed this some material evidences which were
No, but
available in his court.
if you see from page 53, from page 51, 51, I have read this in details. Now it appears that you see, that's why I'm using the word sufficiency.
No, that
correct.
That was sufficient, maybe.
Correct. This
but he has
court
not
this court shall not go into all that, because this court is not the appellate court,
No,
right?
no, that is one thing.
Huh.
But
So here is a case.
supposing there were 4 evidences, he has considered only one.
That is
and
right. If that one evidence is sufficient, now how can this
if
court,
other
Mr.
three
Chalya, see,
evidences were
please
against.
understand
Yes.
that what is before this court is the inquiry proceedings. Now it appears that you are challenging the inquiry proceeding on 2 grounds. Is it correct? You are saying number one, that's on the merit.
There is no evidence.
Number one, on merit, there is no evidence. All right, this court shall look into it. Second is what ground? What is your second ground? First, you are saying no evidence. Correct?
And they have not considered certain materials which were available in record. Or the department.
No evidence and not considered.
Not considered materials which were of the department itself.
Materials.
That I have referred to in the affidavit.
Which affidavit?
In my affidavit in opposition.
Materials available on record. Paragraph of your affidavit?
That I'm giving. Paragraph 5 regarding.
First, just give me the paragraph, then you can read it.
Page 259.
Yes.
Paragraph 5.
Yes. And which paragraph? Only paragraph 5?
Then
five, and then?
Yes, I'm giving. I'm giving. Because in this paragraph, I Actually, it relates to charge number 2 and 3. Charge number 2 and 3. Because in charge number 2, allegation was of JCB, and I did not report. I did not report. That was the allegation. But in this aspect, I want to refer to the guideline of the department itself at page 265.
These have been given before the inquiry officer, these arguments? Because here, article 2, come to page 53. Let's read page 53 then. And then see your para 5. Page 53, 5.3, article 2. Got it? This is article 2, correct?
Article.
You can read. As per the
tax जैसे demand one is one like purchase man CO purchase the one aspect from humans.
CO is the delinquent purchase one earth excavator for a total so and so, exhibit D so and so. Yes.
Which registered department on 1 month, that's a demand in the name of Disciplinary.
His wife.
Yes.
Yes.
As per exhibit D 3 month, for purchase of a sum of rupees 1 month was obtained as loan of necessary equipment finance in one, a down payment of rupees 7.
CO was the guarantor in the said loan.
Yes. When against this loan, HK Pupon CO was a guarantor.
You have these rules, Mr. Das, the power grid CDA rules.
Yes, ma'am. That is already we have annexed in our.
Okay, just okay. Yes. CO did not mention about the purchase.
One thing I want to
See,
point out,
Mr. Chalia,
regarding
please,
cases of 7 lakhs.
the problem is, you see, you're on a limited jurisdiction, right? Before a limited jurisdiction, please appreciate how can this court go into all these now? There are some proof, the materials now, whether these materials are sufficient, not sufficient, that this 226 court cannot go into. I would have understood if it was a case of no evidence which you are trying to show before this court. Your argument is of no evidence, perversity. Now for that, there has to be a case of absolute no evidence. There are evidence that have been discussed, correct? This court cannot ignore it and cannot say that no, this is not the evidence, this should have been the evidence, this is not the sufficient evidence, more things should have come. How can this court in 226 go into all this? This court has to see whether the inquiry proceedings have been held fairly or not.
No,
it is only that part. Whether it has been fair, unbiased, whether full opportunities, natural justice, everything has been given or not. But you are not arguing that. That is not your case, that there has been procedural violence, that you have not been, that they have not acted in open mind, that they have not given you the second show cause notice. These are not your arguments, right?
One thing, one material fact I want to point out.
Yes.
At page 46, down.
Yes. 46, yes.
Page 46 down.
Yes.
The CO had made a down payment of rupees demand.
Yes.
7 lakh for the excavator, and the remaining amount was taken as loan.
Yes.
Again, I go to page 53.
Yes. Page 53. Yes.
The CO is the guarantor only. He has not made the down payment.
Yes, all right. The inquiry officer has taken note of it.
No.
See, you see, Article 2, that is the charge, right? That the CO had made down payment of so and so. While discussing Article 2, the inquiry officer has categorically said that you are the guarantor.
Yes.
Inquiry officer knows.
Regarding
So
that
it-
7 lakh down payment.
So
was not
just,
not
just
by the-
because that down payment is not directly paid by you doesn't discharge you from the charge that has been ultimately leveled. At the end of the day, the charge has to be understood what it is meaning. Anyway, this court is not getting into all this, Mr. Chelya. I'm sorry. Yes, any more argument on this is one argument I've taken note of. Anything else? Your written submissions are there, of course. I shall consider it.
And this
Which
affidavit,
which affidavit?
that page, that I refer to it,
Yes, yes.
paragraph 5,
Yes, that I'll take care of.
259.
Yes.
There, the company guideline is there, where it says that in order to reduce compliance cost of a large strata of honest officers, the commission has observed that its punishment policies with regard to
this paragraph
reclamations would be as follows.
This is for disproportionate punishment.
Yes.
So that's your second ground.
Yes, second ground, for second ground.
All right. Anything else?
Then for the third ground,
Yes, what is the ground?
third ground regarding this excess payment and recovery.
Yes.
Excess payment was alleged to be made by the petitioner and has to be recovered. In that case, a circular dated that I referred to, 28/3/18 at paragraph 260.
This ground is not. What is the ground? I'm sorry, it is not yet clear. Excess payment means?
There were 2 bills were paid with excess amount regarding art cutting and art.
So one of the penalty was to recover the excess payment from
No,
your.
I made excess payment, but the excess payment they say was recovered.
Was recovered.
Recovered later. And they say that it was after inquiry only, they found that it was made excess and that is recovered. But it will be apparent that that recovery was good person you have initiated. Yes. Article 2%. Yes. At page 38.
$38.
No, wait. Yes, sir. That disbursement was carried out on the basis of the circular dated. Yes. At page 31. Dear EA.
31.
31.
31 is part of what? Part of the.
This is part of the charges.
Yes. Yes.
The site by demand was initiated.
Where are you reading exactly from?
Page 31 towards bottom.
Yes.
After the details given in the regarding bills.
Yes.
The site by mandated demand was initiated dated 10/4/18 was initiated
initiated a proposal for recovery of the excess payment towards artwork in excavation and filling.
All right,
or
this
to
has
be
been
rem-
recovered.
Yes.
Accordingly, the
Okay.
amount of 8 lakh so and 15 lakh
Yes,
so and so total so and so
23 lakhs have been recovered.
recovered, yes.
That was initiated on 10/4/18.
Yes.
And the Lordship will see the circular I referred to just now.
Have you
that takes-
challenged the charge sheet? Did you challenge the charge sheet at that time?
No. Charge sheet?
No, this charge sheet, did you challenge at the time it was given to you? Because you are saying this cannot be done because of the circular.
No, they
I'm
cannot
sorry,
be
I'm not getting it, understanding what you are trying to say. That according to you, the circular bans the recovery.
No, circular clarified as to how
the recovery is to be
no,
done.
How it is be calculated.
So you according to you, this calculation is wrong.
Excavation and art filling.
So you are trying to say, in short, you're trying to say the calculation is wrong.
Calculation was earlier done, and however they found it to be wrong, and they themselves have given a circular, and after that circular only recovery was done.
Okay, okay.
Because this circular says, it is very clearly said
Okay.
at page 267.
Page 267, yes.
Method of measurement and release of payments for ongoing works.
Yeah.
There it is, the picture given what has to be.
Yes.
It has to be excavated and filling. They say if it is done in one course, then only one payment is to be made, not for both. It is for excavation and filling. Only excavation and filling was done.
Okay.
In the chart at that time in the bills, and they clarified it on 26/3/18 by the circular, and after that only the recovery was done. So it cannot be said that the petitioner was guilty of making payment for both.
Okay.
For that, this is there.
Yes.
For allegation number 1 regarding page 171. One 163, no, person 161, 171, 175. At page 171 of the paper book, your lordship will find the evidence of Sujya Saitya, on the basis of whose evidence the charge against the petitioner regarding his contract through wife, was found to be proved.
What do you want to show, Mr. Chalya?
At page 172.
Yes, I'm waiting.
I want to show that the excavator was engaged by a contractor
who is not connected.
Who is not connected. Because because it says at page 172, this excavator was being used by Sirajul Islam, who operated the excavator and
In other words, you are trying to ask this court to reappreciate the evidence.
No, not to reappreciate.
Yes.
Only to show that this evidence, had it been considered, that evidence, that finding could not have been arrived at. These were taken into, evidence was taken, but these were not considered. That is my point. Then 163 and 164.
Did you get a second show cause notice before the penalty was imposed?
Yes.
Did you reply?
Yes.
Where is that reply?
I put first this one.
Where is that reply?
B. Page 36.
Page 36.
Answer B.
Yes. The JCB in question was given on rent to Mrs. Sirajul Islam by my wife, so and so. Hence, the JCB was another possession and operation of Sirajul Islam. As per the terms of the agreement, the lease rent could be paid so and so. A portion of so and so executed by so and so was subcontracted with so and so, who was held responsible for crediting an amount of so and so. My submission on this: the JCB owned by my wife was used after taking consent from her, but not me. This cannot be said to be in violation of so and so, since the relatives of the officers cannot be expected to be aware of the Power Grid CDA rules. As for payment of so and so by Surya Saikya to my wife's account, this was based on the bill raised by so and so in the name of my wife. No irregularity can be pointed out since the equipment rental agreement between so and so itself permitted for so and so. So and so. Now, coming back to that page 52, was it page 51? 51, right? I remember reading something about this person. Yes. The fact that it is also established that Nijumoni Gogoi in her bank account maintains so and so from Surya Saikya, a labor contractor. It has been established that a total amount of so and so was paid to Nijumoni Gogoi in her bank account towards hiring charges of earth excavator. There is no document on record to show that the charged officer obtained any permission from the department for the business with the working contractor under his control. The charged officer in his defense produced equipment rental agreement dated so and so, executed between so and so and so and so, for giving the earth excavator on lease for a period of 36 months. This agreement only establishes that the earth excavator was given on rent to Sri Sirajul Islam initially for a period of 36 months at the rate of so and so. The CO during questioning by the inquiring authority claimed that he was not having the knowledge that the said excavator belonging to his wife was used at Phulbari site. In fact, he had so many other works to attend, like works relating to so and so with me, so and for obtaining consent, and as such, he was not going to the site continuously. However, When he came to know that the said excavator was being used at Fulbari, he immediately asked the driver of the vehicle to take away the same from Fulbari worksite. The CO has further taken the stand that his wife was doing business independently and he had no knowledge as to under what terms and conditions and where she was utilizing the excavator. The contention of the CO is not tenable. It was very well known to him that the earth excavator belonged to his wife, and this has been utilized in the works under his control. He has admitted that when he came to know that the said excavator belonging to his wife was being utilized at the work, he should have at least obtained ex post facto approval from the competent authority for the said business by his wife. He also did not raise any objection in the transfer of money to the account of so-and-so was done by so-and-so. And so-and-so. It is worth mentioning here that CO in his signed statement dated so-and-so given before so-and-so admitted that in April 17 on the request of Surya Saikya, he had asked his wife to deploy her JCB at the work site due to non-availability of JCB at Fulbari area. You see, a lot of things are there. I can continue reading. How can this court go into all this? Your written submissions are there. I have seen it. You have taken all these grounds. Anything else? Yeah. Please don't repeat. Otherwise, anything in you want to rely any decision, anything more to add, you can add. But this much is clear now.
Regarding those two bills, I want to say.
Those two bills are not part of the documents on record.
No. Regarding carving of the bills. Interesting language.
Huh?
Interesting language I want to point out.
Interesting language.
Language.
From where?
From their record, from the charges made. At page 32.
Yes. Yes.
Two SAPs, this JMCs were prepared by Sri Sangma on 29/6/17, and two separate RA bills. Second RA bill amounting to 37 Iman and third RA bill amounting to 16 lakhs Iman have been prepared by Sri Sangma and approved for payment by Bhutan, chief manager of the same on the same day on 29/6/17. The bills were prepared and processed at Power Grid Guwahati office. SK Bhutan processed the second and third bill on the same day, that is for 17 lakhs Iman and 16 lakhs Iman respectively, to authorize the bill for payment within his financial power as per the Power Grid DOP. If both these bills happen to be prepared in a single RA bill, because bills are not paid by him, it is paid by the office. That I saw the tracking of the bills. Total amount would have been 54 Iman and his power is 50. For that they want to say that
you made two separate bills.
Two separate bills. As per clause Iman, power to authorize payment of RA bills is up to 50 lakhs, and DGM and above is powered with bills of above more than 50 lakhs. However, there is no record or backup calculation. That I want to show the record regarding these two bills.
However, there is no record backup calculation is available on record site regarding basis. On record site, it says. Regarding basis for preparing two separate so-and-so. So they are saying at the site, record site, why two separate bills was prepared and not one? Because according to them, if it was one, then it would have crossed rupees 50 lakhs and you wouldn't have had the
By him,
Yes,
by
yes.
next of year.
Yes. Yes. Now, this has been proved. The findings are here.
No, prove what way?
Yes, here
Prove what way?
at page 57. As has been narrated under the conclusion findings for article of charge 3,
No,
RA
that
bill number.
that bill, that those bills were separately made, that I want to show. At
But it's an admitted fact that two separate bills, isn't
Yes.
it?
no, two separate bills,
Huh.
but they were not paid, not drawn on the same day. That I want to show.
Not drawn on the same day. You mean to
Not,
say that
not prepared on
not
the same
prepared
day.
on the same day?
Prepared on the same day. That I want to show.
Here they say it's the same day.
Yes.
So that's why you're saying it could not have been prepared at one bill.
Yes.
Because they are two separate
Two separate
dates.
bills. Their own evidence says, Milord. Their own evidence said, bills. And one
But
bill
it
was
said
released on
both
31
the invoices were raised simultaneously. The inquiry officer has taken note of it, Mr. Chalia.
No.
See, it says were raised simultaneously. It doesn't say on the same day.
No.
The bills were signed by Sri Sangma, the junior engineer, and by the CO, which confirms the splitting of the bills. The delegated power of so and so, and again, the same thing is so and so.
One bill was raised on 31/5. That
Yes.
also in the evidence.
31/5 of 2017. And the other one?
And other one was raised on 27/6/17.
Okay.
And forwarded. These two bills were forwarded. And for that I will show the evidence also.
And is there anything to show that it were signed on the same day?
No.
And passed on the same day, because the inquiry officer have said so. So you must be having those records. You are holding it. Page 58, it is said, the plea is not sustainable because both the bills were signed by Sri Sangma, the JE, on the same day and also passed by the CO on the same day. In fact, the amount of these two bills exceeded the delegated power of the CO, and he should have sent the bills to the next higher authority for payment. It doesn't say you are not being held guilty because you prepared it on the same day. They are saying
Payment. No, that we mean, had it been one, happened to be one. Charge you have language. Had this been happened to be one. Happening of an event, can that be an imposed ground Milord?
This is understood. Anything else?
No, that I am giving. No, it doesn't forward for me.
You have the records, Mr. Das.
Yes.
Huh?
The entire proceeding of the actually I have entered in my affidavit also, madam.
You have the entire proceeding has been.
And even that I am holding.
All right. I think Mr. Das, you also prepare a small written arguments indicating all this. I will close the arguments today, but I'll fix another date when you can give your written arguments.
That today also I am not feeling well, my lord.
No problem. We can accommodate you on another date. Let Mr. Chalia finish.
Page 149.
Sangma evidence. 149.
Yes.
regarding those two bills. Tracking record. 149, this is the person who prepared the bills. Towards bottom, the RA bill number 2 is signed by me and also by S.K. Phukan on behalf of Power Grid and representative of the contractor. As per the bill's movement sheet, the bill was raised. This is important. On 31/5/17 and received by engineer in charge on 29/6/17 and forwarded to the finance on 29/6/17. As per
Next verse, one. Only parking the revenue.
then 150 towards middle 150. As per similarly as RA bill number 3, the date of billing is mentioned as 27/6/17. Contrary raise the bill and my signature is dated 29/6/17. Like to add the GST and other things from these two bills were prepared in haste and before the applicability GST. I am not aware as my yes, earlier, first paragraph. As per bill's movement sheet, the bill was raised on 27/6/17 and received by engineer on 27/6/17 and forwarded to the finance on 29/6. So it cannot be said that those were raised on the same day.
No, on 26, 27, it was
and signed on 27.
Signed and ultimately forwarded the
Forwarded to
finance.
finance
But the
on
finance
29.
is going to release the payment.
Yes.
The CO is not the finance, right?
No, two separate bills were sent to him and they were paid separately. And only for that, Milan, in the charge they have said that this happened to be in the same bill.
Okay.
Happening of an event, it is ridiculous language.
Yes, anything else?
Because the evidence is there, Milan, regarding the raising of the bills on separate dates, and they were paid separately.
Okay.
Although on the same day.
Oh, although on the same day.
Although on the same day.
Okay.
They were raised on different dates as per the track record of the bills.
Okay.
Regarding Article 3, I have already mentioned regarding the circular they have given, and for that only the EO was taken. So
okay.
That imposition
okay.
or the upon the petitioner Miller,
all right,
is not properly done.
Yes, Mr. Das, on which day you want to give your reply? On that date, Mr. Das, you also give a written argument. Just you choose your day, next week, day after, or the week next, whatever. When do you want it?
Then because let it be under next week, my lord.
Any date, because today you said you're not feeling well, so I'm accommodating you. 12th is Tuesday. Just once. Once. I am available, but I'll just check. I think we may have fixed because I think another half probably will be required in this matter.
I will not take much of your time, my lord.
Rupak, Tuesday, next Tuesday, then Thursday. No, easy as. Huh? 14? Is 14 okay? You have any difficulty on 14?
Input number 1.
Acha. 14. We can try on next Friday actually. All right. Okay, after that Tuesday.
That will be on 19th.
19th or 19th. Okay. Heard Mr. Okay. No problem. Heard Mr. DP Chalia, Learned Senior Counsel, assisted by MS Roy. Learned Counsel for the petitioner. Also heard Mr. NC Das, Learned Senior Counsel, assisted by Mr. N. Khera, A. Srivastava, and Mr. A. All right. So and so. Mr. Chalia, Learned Senior Counsel, has concluded his part, his argument on behalf of the petitioner. Mr. Das, so and so has sought for a short accommodation as he is not feeling. You don't have to write that. Fix on such and such date for further hearing.
Understood.
Your argument is already there on record. Just come up with a consent date and give it to him. Yes.
Item 31.
Yes.
Mr. Lordship, kindly pass over the matter for the day, Lordship.
All right.
Here is
As
the list.
prayed for by MS
D. Devi.
G. Devi.
D. Devi.
D. Devi, Learned Counsel, appearing for the petitioner, which is not opposed by Mr. J.K. Goswami, Learned Additional Senior Government Advocate for the state respondent. Relist next week. Relist next week on a date to be fixed by the registry.
Item 34.
Mr. Lordship, my senior Mr. M. Khan is lacking the court number 9.
As prayed for on behalf of by Mr.
A.K. Das, Lordship.
A.K. Das, Learned Counsel, appearing on behalf of the petitioner to the effect that the arguing counsel, Mr.
M. Khan.
M. Khan is on legs on another before another bench of this court, which is not opposed by Mr. T. Sijotia, Learned Additional Senior Government Advocate for the state respondent, relist after a week on a date to be fixed by the registry.